Number 13.
13.
Yes, ma'am.
Yes, what do you want?
Number 13, I have furnished the copy. I am the respondent number 1 of this pin mark. I am the respondent number 1,
Yes.
and now we are going to find our documents now. Affidavit.
What documents?
This
Is it-
affidavit.
What is IA? IA for what?
It is the interrogatory application now. Which application for condonation?
Okay.
It is
Then.
filed by one Ritu Kumar appellant,
Hmm.
and I am the respondent number 1.
Here in
So-
IA.
Yes, my lord.
Your Lordship, I'm appearing for the appellant in this case.
Yes. What do you want?
We have
What
filed
do you
the
want? You want to file an objection?
Yes, my lord. Today.
Whatever.
Today, sir, my lord.
You're seeking for some time.
Yes, my lord.
Heard Mr. On the prayer of Mr.
N. Biren,
N. Biren, learned counsel for the respondent.
number 1.
Respondent number 1. List this matter after 3 weeks so as to enable him to file objection in the IA.
Your Lordship, if a fixed date, maybe I think
After
so. So
three
he's from
weeks.
Manipur.
Yes, we are coming from Manipur, ma'am.
So when?
After Christmas, my lord. So 15 January.
15 January. Listed after on 15
15.
01.
Can it be in the after 15, Your Lordship, because it'd be difficult, Your Lordship, the 15.
After 15 when?
We have
20th, Your Lordship, it's a Monday.
We are coming from Manipur, so we are.
So your friend is asking that 15 is not possible after 15th of January.
Before,
If it can be on the 20th, Your Lordship, it's a
13th.
Monday. So also can come from Manipur.
13. I think 13 is holiday. 15 is also, I think, holiday.
20th, Your Lordship,
15.
20th. 20.
20
of January. It's a Monday.
20. Huh?
Pardon?
When, sir?
20th of January.
20. It's working.
I have some difficulty to 2021. I have difficult.
Then thereafter. After
Thereafter.
21. After 21, just give.
23.
23.
All right, Your Lordship.
Then my name may be shown as record number 1.
The name of Mr. Registry to reflect the name of Mr. N. Biren in the cause list as respondent number 1 in IA. Yes.
Oblige.
Highly obliged, Your Lordship.
Why, please, Rose?
Yes.
I would like to mention item number 6 and 7.
16,
6 and 7.
6 and 7.
Yes, Lord.
Yes.
Conducting counsel, Mr. K. Lawley, fracture on his leg. He could not.
When?
Yesterday, he played the football.
Who?
K. Lawley, Lord.
Okay. Mr. Jita learned counsel for the petition respondent 6 and 7. Huh? Same is there. Mr. K. Lolen, a conducting counsel, has sustained some fracture in his leg or hand. Leg. Therefore, matter may be adjourned for 3 weeks. 4 weeks.
1 week, Lord.
Huh?
1 week.
1 week, Mr. Prayer not being objected to by learned counsel for the petitioners. This matter after a week.
Deeply obliged.
Yes. Yes, Mr. Khambo,
Your Lordship,
hurry up.
yeah, so I beg to mention item number 10.
10.
Yes.
Yes.
Conducting counsel, he comes from Guwahati. Today he
On the
could.
prayer of Mr.
Yes.
Item 10, bail
Yes,
application.
bail application. Yes.
on the prayer of Mr. N. Khambo, learned K.
M. Khambo.
M.
Yes, M. Khambo.
M. Khambo, learned counsel appearing on behalf of Mr. And on the
Yes,
prayer of
Khambo.
Mr. N. Khambo, learned counsel to the petitioner. List applicant, list this matter after
Your
Three-
Lordship, I have a specific instruction
3 weeks.
to
When?
have a fixed date
One.
on 4th of December.
After 2 weeks. After a week. This is the matter on 4th of December. Yes.
Obliged.
Ma'am,
Yes.
the short question involved in this criminal revision petition, my lord, is whether the executive magistrate has a power to award compensation, decide the cancellation of the LPC, and also to an extent that whether it has a power under section 152 and 152 to 166 of the BNSS. That is, my lord, the old section 133 and 145 proceedings, my lord, has a power to adjudicate concerning the dispute between two parties. So, my lord, kindly come to page 18, that is annexure. This was the first complaint laws. This is the re-complaint laws, my lord.
Let us see the complaint of intentional earth cutting at Bensuensha. Yes, by whom? Against you?
Against me by this, my lord,
What village development committee?
yes,
Earth cutting.
correct.
Then next page is, it's a
Next-
type copy.
Type copy, my lord.
Restricting violation, breach of agreement upon terms and conditions agreement to ensure by Tata Temple sign person human risk loss of property. Yes.
Then thereafter, my lord, in this re-complaint, my lord, what had happened? The previous minutes, whatever were directed, we have complied with. my lord.
It has the impugn order has arisen out of this.
Yes, impugn.
Let us see the impugn
yes,
order.
Impugn order, my lord, will kindly come to page 69 straight.
69.
69.
69.
Yes, annexure 5.
Yes.
My lord, in fact, one or two paragraph we can read and then we come to page 75 straight. The case was listed on 10/10/2024. In attendance were Mr. So-and-so, 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 so-and-so. Para 2, the respondent represented by so-and-so, also present. The fact, para 1, look. The fact of the case is that the district Itanagar has endorsed to the undersigned two related matters. White, so-and-so, a complaint submitted by Bath 2 Village Development Committee Itanagar alleging illegal art cutting at Bath Village 2 in the year 2021 by Mr. So-and-so, and also so-and-so. The resultant downstream silting and the submergence of settlement areas and subsequent violation of the terms and conditions of the agreement dated 9/12/2022. B, my lord, white order dated so-and-so 27/8/2024. The recommendation of a committee constituted by Deputy Commissioner Itanagar to verify the facts of the above case. As for the so-and-so. Now, my lord will kindly come to para, that is the fact of the case. And then, my lord, I will demonstrate in terms of that 2021 order we have complied with and also that, and then how this impugn order is not sustainable, my lord. Now, my lord will kindly come to page 75. That is the operating portion of the order.
Yes.
75, my lord.
Hmm.
Para 19.
Hmm.
The respondent shall construct one retaining wall at Kulum stream and shall initiate the work within 10 days of issue of this order dated 18/11/2024. and shall complete it by 31/12/2024. 20. The respondent shall transfer physical handover 3,000 here, Miller. 3,000 square meters of suitable habitable construction worthy land to the complainants on or before 30/11/2024, or in lieu of it shall hand over to the complainant an equivalent amount of money at the prevailing market rate of the land in the area. The Deputy Commissioner is free to issue an immediate prohibitory order against all sale of land by the respondent until the penalty in the land stroke money is realized, to be rescinded once the penalty is paid. 22. The Deputy Commissioner is free to consider the cancellation of LPC number so and so dated 1998 for plot measuring 13.37 hectare issued to the respondent 1 in case of. Now, my lord is aware. The proceeding under section 133 to 146, these are injunctive in nature to prevent immediate nuisance or apprehending a law and order resulting into the loss of human life. Now, my lord, what happens? Once these proceedings under section 133 to 146 of the CRP is violated, then 188 comes in the penal code. Contempt for violation of the lawful order promulgated by the authorities. Now, my lord, what had happened? Now, there is a bar under section 195. My lord. Now, here it says, whose order?
No,
whose-
under what authority has decided this? Yes,
Yes, absolutely, Lordship. I would also, because.
at best, if there is something, if to prevent earth cutting or something, I mean, then you can, there your provision appears
Yes.
to be that jurisdiction.
Because this order has been passed under what provision is not.
Yes,
No.
cannot,
Absolutely.
realistic for a time. being.
Yes.
Heard Mr. Titi Land Council for the petitioners. One petition, one,
Two.
petitioners.
My lord, it will be applicants rather.
It's all right. This is criminal petition, petitioners.
Correct.
Uh, This application is filed assailing the impugn order. We should say judgment or what?
Judgment order.
Impugn
It's a written judgment and order.
impugn order and impugn judgment and order dated 08/11/2024 passed by the executive magistrate, Ethanol Complex. Page 69
Correct, my lord, 69 to 75. 75 is the operating portion of the order.
in case number EM public page 69, huh? Eta public case 2024/34/303, whereby the executive magistrate has decided certain disputes involving the petitioners and the private respondents. Issue notice returnable by 4 weeks. MS TG London. Additional PP appears for the state. For respondent number 1, next para. London Council for the petitioners to take steps for service of notice upon respondent 2 and 3.
Two ends.
Only 3 respond, 2 and 3. By registered post so and so, huh? I think you need to file an petition here. I mean, the affidavit,
We-
making your stand on the, I mean, because they need to know the procedure,
Yes, Your
isn't
Lordship.
it?
Yes, Your Lordship. Just
Anyway, you may make your, that also, you may make the submission on low point. Next para. Having considered the submissions of the learned council for the parties, next para, huh? And on perusal of the impugned judgment and order passed by the learned executive magistrate. Come on, it prima facie appears that the learned executive magistrate has exceeded his jurisdiction, not conferred by the law. Listen. Accordingly, in the interim, the impugned judgment and order dated 01/11/2024, 2024, in case number so and so, passed by the executive magistrate. Eternal. Shall remain state. Shall remain listed till the next returnable date.
Well, may I pray for until further order? Until further, order, because they will be filing affidavit.
We'll see,
no,
we'll see, because it's involved the property,
Correct, correct.
including the earth cutting, which we should
That
not,
was
we should not
compensated.
encourage.
Well, that was compensated.
Anyway,
Great.
May I please?
yes,
Lordship, this is a joint petition for quashing the FIR 25/2023 registered as Likavli PS case number 10 of 2023 under section 447, 384, 506, 34 IPC.
in this, not only you,
Yes.
in this fashion, if the criminal petitions are filed, there will be no investigation and there will be no trial. Why so many quashing petitions? Yes, Mr. Dickey. Unprecedented number of criminal petitions for quashing. From FIR, charge sheet, trial. In that case, nothing will remain for investigation and trial.
Joint petition.
Yes. I think we need to look into seriously. Not that liberal.
Depending on the circumstances and the nature of.
No, maximum, we thought if there is a genuine, settlement, we try to
Yes.
understand in certain cases, we just take a liberal view that if the parties are really, and it doesn't, it's not, the offense is not
Yes, yes,
heinous or serious or affects, society. We looked at, but then the number of cases are being filed and listed every day. I think virtually there will be no investigation, no
No trial.
trial, nothing. We will have to be little rigid now.
Yes.
All right, we'll issue notice, that's all. What is the offense? What is the offense?
Only 384 is
What is 384?
the extortion.
Yes, this is very dangerous. How you can compromise that?
In fact, Your Lordship, there was no any extortion. It was out of anger and
Anyway, for today is the last day for this session. So,
already Your
heard
Lordship,
Mr.
they have appeared and
It's all right.
yes,
This is FIR or
the
the
proceeding.
proceedings? Okay, heard Mr.
Style.
Yes, the learned counsel for the petitioners. Next para. by filing this application under section so and so, huh? BNSS 2023. The petitioners jointly, by filing this petition, jointly by the petitioners, huh? Under section so and so, the petitioners have prayed for quashment of the criminal proceedings in GR case number 56 of 2023 on the basis of the settlement between the petitioners. Call for the scanned copy of the trial court reports. MSL Hage London Edition PP appears for the state. Next para. Pending production of the case. No. Pending production of the trial court record, the proceedings of further proceedings of GR case. Number 56.
23.
56 of 2022 still remain stayed. He said that pending before so and so, under section so and so, huh? You just right. So this is page 1 and 2. Huh? Pending before which court?
CJM Pasiga.
Chief Judicial Magistrate. You just right. This
Yeah,
after 4 weeks.
All right.
What is the section?
Lordship,
Yes,
333.
FIR.
Yeah, two FIRs.
Watching of FIR.
Yes.
Huh?
Yes, Lordship.
2 FIRs.
Yes.
One was FIR, this is 28th.
28 August 2024. Settlement has been done, Lordship.
What is the offense?
333. In one FIR it's 333 and another FIR it's 333 117 plus 2
What is the offenses?
trespass, Lordship.
Trespass and
Yeah. Trespass and causing voluntary causing grievous hurt, criminal
so
intimidation.
issue notice will not state investigation. Huh? Heard Mr. So and so, learned counsel for the petition.
He comes out.
This joint application is filed by the petitioners under section 4527 of BNSS 24, praying for quashing of FIR dated 28 August 2024. And no, in which has been registered as ITA PS case number 146/2024 under section 333 of BNS 23 and FIR dated 28/08/2024 registered as ITA PS case 148 of 2020 under section 333-117 within bracket 2 bracket close 351 within bracket 3 oblique 324 within bracket 4 bracket close oblique 3 within bracket 5 of BNS page 1 and 2. Huh? Call for the case. It's in copy of the case there. MS TG London PP is for the state. List after 4 weeks. Just after 3 weeks. Yes.
My lord, this is also joint petition for enforcement of the FIR, madam.
If this is also a quashing of the FIR,
Yes,
no,
madam.
this criminal proceedings,
Yes, madam.
including the FIR, so will not admit, will not issue any notice. It's a joint petition.
Yes, madam, joint petition, my madam.
Why joint petition?
My madam, on the settlement between the parties, my madam.
How you have come into settle this? What is the basis of settlement?
Actually, my lord, it is case of accident, my lord. You
Yeah.
know, offense involving in this case is 279 and
So,
338 of IPC, my lord. So,
In accident, there is no offense.
offense, but it was not intentional, it's happened, my lord. It's
Yeah.
happened, my lord. So, there was no Any
Okay.
intention and will be mine.
This same page 1 and 2. GR case number 461 of 2017. Under section 279, 338 IPC, pending before the judicial magistrate first class. UPR. Two cases.
Yes, my lord.
Okay. Order, call for the case diary. Call for the trial court, scan copy trial court records and so. MS L. Aguilan is the additional PP. Appears for the state. Pending production so and so and so. The further proceeding of GR case number, criminal proceedings of so and so.
My lord.
State.
I want to place the MLC report of patient number 3.
Huh?
Oh, it's okay, ma'am.
No, let me know. What is that?
Oh.
What is that?
MLC report, ma'am.
What is this?
Injury report also.
MLC report of patient number 3, my lord.
Next year, why?
Yes, yes, my lord. Actually, what happened in this case, the record room of the Nane trial court did not furnish me.
Don't put it here.
So
Bring
it's
on,
not
bring
only
on,
like what it
bring on
was.
record whatever you want.
Yes,
Yes.
yeah, ma'am.
Next. 3 weeks.
No, this is also a quasi petition.
It is also joint petition.
Yes, joint petition.
Same. In GR case number 275 of 2018 under section 341, 324, public 34 IPC. That's all.
Lord, 323,
Then in that case, we'll say its charge has been put under 324.
yes,
324 and 34 only.
Yes,
In
only.
the- Under section. GR case number 275, 2018 under section 324 oblique 34 of IPC. Call for the skin committee trial court so and so. MS L. Hagelan addition to so and so. Pending so and so. Further proceeding to the GR case so and so.
Lord,
List after 3.
yes, Lord, since prosecution witness is going to be
We
examined.
stayed.
Right now.
What is this?
Appeal, my lord. I am impugning, my lord.
Will issue notice.
Yes, in 8, I have also, my lord. I am praying for
We'll
stay.
issue notice in both. Well, on next day, let them appear. We'll hear you. We'll consider it. All right.
No, my lord.
What is the IA?
I am, my lord, I am praying for stay, my lord. Stay where it is required, my lord. My lord will see, my lord. In this case, my lord. Though I file a divorce suit, my lord. Now,
Which
trial.
one you are? Which one to be taken up? RFA or?
RFA, my lord. I filed a title suit, title claiming divorce, my lord. Now, the trial court, my lord, found that, my lord, it is devoid of merit, my lord.
Where it is? Page.
Page, my lord, 19, my lord.
19.
19, my lord. Start from 19. My lord will kindly look at 33, page number 33, my lord. This is the operative part, my lord. Para 31, my lord.
30?
33, my lord. Page number 33, my lord. 31, I am reading, my lord. Accordingly, the suit is liable to be dismissed with cause. However, considering the fact that the plaintiff is already living with Miss Such and Such since after release from the custody in 2020 after incident of 2020 and had a child Besides, he is totally unwilling to continue the marriage with the dependent, or to the dependent is ready to continue the marriage. The interest of justice, in order to settle this permanently, I am inclined to allow his alimony to the dependent as the plaintiff has no valid reason to obtain divorce, my lord. That therefore I have inclined to impose 30 lakhs, my lord. Now, I am serving as a constable, my
You are
lord.
defendant.
Constable, my
You are
lord.
defendant.
I am the plaintiff, my lord. I by the
Okay. Mhm.
Now, I believe, my lord, humbly believe, my lord, divorce, my lord, the alimony, my lord, cannot be in form of punishment, my lord. Now, if this is 30 lakhs, my lord, this is imposed in punishment, my lord. As my lord, the dependent, my lord, is getting maintenance, my lord. I am giving a maintenance, my lord, in terms of
You file a divorce.
I file a divorce, my lord.
Then
the trial court found that, my lord, that was devoid of merit, my lord.
Yes.
But that was allowed, my lord, with this cost, my lord, huge cost, my lord, 30 lakhs, my lord.
you have married another wife,
Yes, my lord.
second wife,
Second wife.
and then you want to divorce the first wife.
First wife, my lord.
The divorce petition has been dismissed.
Dismiss, my lord. No, allow, my lord, with a cost of 30 lakhs, my lord.
Hmm?
That has been allowed, my lord, with cost of 30 lakhs, my lord.
What is this? According to suit is liable to be dismissed with cost.
Liable to be dismissed, my lord. In para 32, my lord. Therefore, I am inclined to impose a
No, then although the defendant is ready to continue the marriage, in the interest of in order to settle the dispute permanently, I am inclined to allow the plaintiff. Okay. Is liable to dismiss, but then the virtually, in fact, it has been allowed with alimony. What's this?
my lord, that is, my lord, that's why, my lord, I am serving as a constable, my lord.
Doesn't
Now-
matter. Then why have you thought of?
That
First
can be, my
wife-
lord, that's why, my lord, I am praying for estimate. Ultimately, this is a matrimonial dispute. Later,
Will increase the alimony.
my lord, I
50
humbly believe, my lord,
lakhs.
I humbly in the suit, my also, my lord. There been no counter claim, my lord. There been no issue frame about
Forget
my
about that.
capability to pay
You
such-
you married second wife,
My-
and then you filed a divorce
Yes, my lord.
divorce petition.
My lord. That is true, my lord. That
What about her life? She's willing to be with you.
Yes, my lord. That if
She's
that is so,
willing
my lord.
to. You take her back.
Yes, my lord. That can be. That's why I am praying for stay, my lord. Let that.
Then why you file a divorce petition?
No, my lord, my lord.
Divorce is for restitution of conjugal
my
right.
lord, no. Situation, my humble submission. Let stay, my lord. Let the respondent
Will not-
dependent appear, my lord. As this is a
Issue,
matrimonial, there
issue notice.
there
Pray
will
that
always
this RFA doesn't come to this court again.
always possibility of my lord reconciliation.
But issuing
I
notice,
humbly
that's
believe, my
okay.
lord.
Still, it's not done.
And legally also, my lord, why I am saying this problem. That if my lord see, my lord, no issue, my lord.
Why stay?
There was no counter.
Why should they stay this?
My lord, these 30 lakhs, my
What is
lord,
the ground?
ultimately that will affect my other dependent, my lord. I have as much as 7 other dependent, my lord, in terms of this judgment also. My lord.
Why have you not thought of it before?
My lord, that way, my lord,
Before go for a second wife.
I concede, my lord, there
You must be able to take care of all the wives if you want to marry also.
yes, my lord. That's why, my lord, I am praying stay, my lord. Reconciliation is always possible, my lord. If
Will
this,
not stay, you reconcile.
my lord,
Come back we'll hear her also and we'll pass the order.
my lord, legally also, my lord, there is purpose, my lord. Why? Because, my lord, this needs to
We
be.
find it very, alimony is less. Will enhance it.
My lord, see, my lord, in this petition, my lord, in the written statement also, there is no counter claim as such, my lord. Now, in absence of any issue, my lord, being framed about my capability, my lord, to pay
So
alimony, my lord.
in that case, you deposit 50% before the trial court.
Well,
Will stay this.
that, my lord, in my side, my lord, see,
15 lakhs you deposit within
I have
15
much
days.
7 dependent, my lord, other 7 dependent, my lord, including my.
That's why I
18
said,
mother.
why have you not thought before it? Before go for second marriage.
Truly, my lord,
You don't have a guts to, take care of the wives and you are venturing on to marry a second wife.
my lord, to that extent, I totally concede, my lord. But my lord will see, my
And
lord.
then you file it.
For my mistake, my lord, other dependent will not suffer, my lord. Yes, whatever my lord has said, my lord,
It's your responsibility. You have created and you have to resolve it.
yes, my lord, my lord will give me that chance, my lord. Let me, my lord,
15 lakhs you deposit within 15 days.
no,
Then we'll stay this.
not possible. He's constable, my lord. Constable, sir, constable.
That's why I'm repeatedly saying,
It's not possible.
you should have think it before.
That, my lord, that part I am considering, my lord. That part I have not done, my lord. That is my mistake, my lord. That I am considering. But my lord, it's my future, my lord.
See, certain cases involve the human considerations.
Yes, my lord.
And the matrimonial dispute is very, I mean, kind of very sensitive matter.
Yes, my lord.
Someone's life will be ruined.
That him in terms of human consideration, I am praying for stay, my lord. Let him appear, my lord. Stay, ultimately reconcile possible, my lord. In terms of his survival, my lord, he is now in terms of magistrate order, my lord. He is getting 16,000
Where
maintenance.
she
my
is
lord.
now?
See,
Is she a working lady?
no, my lord. Who is
How-
getting maintenance, my lord, from my
What about the kids?
pardon, my lord.
How many children?
We have no children, my lord.
Okay.
I have two children, my lord. And in terms of this two children, and other my younger brother and
Out
sister.
of this, you and the respondent,
No, my lord, no children, child.
no issue.
No issue.
That is more serious again.
No. Therefore, my lord will give me his son, my lord. Reconciliation is always possible, my lord. But in terms of his survival, my lord, he's getting maintenance of 16,000, my lord, from my salary, my lord. They directly deducted, my lord, in terms of
16,000.
16,000, my lord.
16,000.
My lord.
What is your salary?
See,
Gross
now
salary?
62, my lord. Now 62, he is getting 16, my lord. I have other
Will
6 dependent.
will direct the concerned court to enhance the maintenance 50%.
My lord, that will give punishment to be made sufferer to other dependent, my lord. So my take him in consideration, my lord, taking her side or not my for other dependent, my lord. I have a 67 years old mother also, my lord. So looking into those aspects, my
Not
lord.
Mr. El Perme, learned counsel for the appellant. This appeal is filed assailing the judgment and decree
Yes, my lord.
dated, which one?
21, my lord, 9 to
21?
24,
09 2024.
my lord.
Passed in. What is the
Divorce suit,
PSG passed in PSG divorce case number 07 of 2022, whereby the appellant has been directed to pay rupees 30 lakhs as one-time alimony to the respondent, including the cost of pain and agony or abortion and other, etc. Yes.
my lord.
It's not simple alimony. It's a kind of sorry, sir.
No, my lord.
Issue notice returnable
That
by
also I have explained, my lord.
3
That
weeks.
way, my lord. My
We
lord,
will hear you.
if my lord kindly see, my lord.
We'll hear both the appellant and the respondent.
My lord, that way, my lord.
Issue notice returnable by 3 weeks.
If my lord allow me to read this judgment, my lord will say that was
Learned counsel
in
for the
Medicare term, my lord,
appellant
that is
to
not
take steps for service of notice upon
if
respondent.
topic, my lord.
How many respondents? Only one.
One, my lord.
Responsible
In
respondent.
Medicare term, that is not
Registered press, so and so, so and so. Huh.
judgment. If my
Then-
lord sees in judgment,
IA.
I am.
Heard Mr. El Permit learned counsel for the appellant, applicant appellant. Issue notice.
Still returnable that my lord will kindly stay, my lord. quickly transmitted, my lord, and let them appear if they have any objection, my lord.
Yes, right. And this is an application and order 41, Rule 5 of CPC. Praying for stay of the judgment and decree dated 21/09/2024, passed by the district judge in divorce suit being PSG, that same divorce case number 07 of 2024. Issue notice, returned, issue notice to the respondents, returned by 3 weeks. Then consent for the petitioner to take steps for service of notice upon the respondent.
Still returnable that, my lord. Because, my lord, if judgment, my lord, I allow to read my judgment. That is not if topic, my lord.
Still
Now,
return-
that
Having
abortion, my lord.
Having considered, having perused the judgment and decree, till returnable that the impugned judgment decree shall remain stayed subject to the deposit of 15 lakhs. Before that,
My lord, 15, it ought not be, not possible, my lord.
subject to the deposit of, if you don't deposit, we'll see.
15 day, my lord, I'm serving mere constable in IRBN, my lord.
See, look, read the last.
That way, my
It
lord.
is for abortion,
Yes, my lord. That's why in judgment, if my lord, judgment say, my lord,
mental pain, agony. You see,
if evidence also I have.
no amount of I mean, no matter how high the amount is, you cannot compensate the agony and pain.
No, that's why, my lord. That's why, my lord. If my lord, if,
And you are saying that you don't have an issue and you got it divorced, aborted, and you are saying that there's no-
my lord, will give me kindly give 2 minutes, my lord. Now, in terms of that, that is in medical term, that is ectopic, my lord. Now,
We'll
pregnancy,
see,
my
we'll
lord.
consider that.
Pregnancy.
We'll consider that, sir. We'll consider.
My lord, can one in terms, my lord. That's why, my lord. Even if his her deposition, he accepted yes, my lord. That a person done to save her life, my lord. When the my lord pregnancy, my lord, occur
Yes,
out of uterus, my
you
lord.
just write not 15 lakhs. You just write 50% of the decreed amount within bracket 15 lakhs.
Instead of that, my
We'll
lord,
make it clear.
15 lakh. My lord, just to clarify this, my lord. When that is not in medical the ectopic, my lord. The pregnancy when occur in out of uterus, my
We'll
lord,
consider.
to
we'll
save
consider.
to save the life of mother, my lord. That is
We'll
necessary.
consider. I'm not saying that you don't have a case. You may have a case,
No.
but look at it is only for time being.
My instead 50%, let it be, my lord, 1/3, my lord. 15%, my lord, is the 50% is for one constable, my serving is for that is too much for one.
Then we'll make it.
One.
You just tell 1 more 10 lakhs. All right. Yes.
Yes, Lordship, I am for petitioner in this matter.
Yes.
Lordship, this
What
is
complaining.
quashing petition
Yes.
of FIR dated 15th July 2024 under section 318 of BNS registered at PS Naharlan. Lordship, in this matter, petitioner and respondent both are businessmen and doing business of kitchen steel equipments. There is a business transaction between the two and established contractual relationship, and both are in business since 2019. Lordship,
Yes.
on 25th September 24.
Who is for respondent number 2?
My lords, I appear on behalf of respondent number
Okay.
2 to BC.
Yes, it appears to be a business, purely a civil dispute.
Yes,
My
Lordship.
lords, one second, Mr. Counsel, please allow me to submit.
On 25th
My
September,
lord,
the
this-
Lordship agreed that this is not a criminal case and it is not justified to lodge FIR in this matter. Rather, it is a case of civil nature. And Lordship had directed the petitioner to appear before IO at Naharlan police station
Yes.
to record his statement and following the direction of the Lordship, petitioner appeared before IO and got his statement recorded on 29th September. And Lordship again thereafter 30th October, the petitioner again joined investigation through Zoom meeting and once again recorded his statement to the IO, and petitioner also made available to the all the document demanded by the IO, like GST registration, Lordship, like GST monthly return, quotation of booked item, and Lordship also photograph of prepared items. And Lordship, I want to mention, I was ready to deliver the booked item and I am still ready to deliver the prepared item. Items are prepared. I have filed affidavit with the photograph of prepared item. Items are already prepared and I have never refused to deliver. But Lordship, respond number 2 refused to pick the items because his personal reason, because the order of his next party was cancelled and he refused to pick the items. This is only the issue between us, Lordship. We are businessmen, we are in transaction.
Okay. I want to, we'll hear him.
Yes.
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 Respond.
Milord,
No, before
on the
that,
factual-
yes. PP,
Yes,
do you have the records?
yes, Lordship.
CD, case diary.
Yes.
What is the latest status? He said he has appeared, he's cooperating, and he has given his all his record statement.
Lordship, he's appeared, but his statement is not, Lordship, collaborating with the evidence that provided, Lordship, with the whatever the accused has submitted, Lordship. There's no documentary, Lordship, evidence, Lordship.
Obviously,
Lordship,
how this can be, how his statement can corroborate the evidence filed by the
so, Lordship,
complainant?
this is simply investigating, Lordship, process, Lordship. At that time, Lordship have some judgment also, whereby, Lordship, although it is sitting care for
Sir,
this permanent
Madam,
transaction.
will come to the judgment. We are yet to understand the facts.
Lordship.
Not only facts, the
Lordship,
status.
Yes, Lordship. Here, Lordship, as per the Lordship, the investigative agency, Lordship, they have, Lordship, earlier also, they failed to appear before the investigating agency for the statement. Later on, Lordship, after,
I
Lordship,
just wanted to know. It's okay. It's a quasi petition.
Lordship.
No issue. According to him, he has he's cooperating. He has recorded his statement has been recorded. The issue is out of a business transaction. Is there any ingredients, any material on the record
Yes, Lordship,
to show
yes.
that there was any element of an ingredients of 420?
Yes, Lordship, it is there,
Show
Lordship.
us.
Lordship, as per the Lordship, this
It appears
status,
to be
Lordship.
a simple breach of contract.
Whatever, but Lordship, Lordship, my humble prayer, Lordship, let the trial may be concluded, Lordship. Let the trial may be processed because the questioning the entire
No,
proceeding is not.
if it is privacy, if it is a simple, pure breach of contract, what is the question of trial?
Lordship,
You cannot have a criminal color on it.
Because Lordship, we had Lordship, whatever the accused statement recorded, is
See,
not.
madam, just because someone in a business, the transaction, if there's a criminal, breach of contract, there's an appropriate remedy.
No, Lordship.
You cannot
Lordship,
resort to the shortcut method.
Lordship, if that accused is not, Lordship, if he is, Lordship, innocent, then he will be acquitted, Lordship, in the
No,
trial process also, Lordship. But they
we
simply
cannot
because,
allow
because-
such a proceeding.
simply because,
If
Lordship,
prima facie, if it is a breach of contract,
Only-
rather than a contractual
Lordship, my humble prayer,
business transaction,
my humble prayer,
why
Lordship.
the criminal thing should be
Lordship,
put
all the
into
commercial transaction, all the Lordship civil, it not need to be Lordship quasi at this stage, Lordship.
I understand.
There should be Lordship.
That's why I want what is the material on the record.
The material is
Which
there.
shows that there is a criminal, which shows the ingredients or the
Lordship,
criminality of
there's Lordship bank
the
trans-
petitioner.
The transaction, Lordship, there is WhatsApp communication, Lordship. There is other witnesses statement also there. Everything is against him, Lordship. That's why, Lordship, the fair trial is need to be processed, Lordship.
Heard, Mr.
If I may.
Heard, Mr.
Sandeep Dahiya, Lordship,
Learned Counsel for the
petitioner.
petitioner, and also heard MS L. Hage, London Additional PP, who has submitted that he has received the case diary, case records, case diary.
Case study, Lordship.
It's in
Along with the status
scan,
report.
scan copy or original?
This is scan copy, Lordship.
Scan copy of the case diary. According to the learned PP, additional PP, materials on the records privacy discloses the offense under section 420.
420.
Yes, my lord, erstwhile
It's
420,
420.
now
Last way,
320.
last way also had Mr. What's your name, please?
Sandeep Dahiya.
Lordship Aditya Agarwal.
No, respondent.
Sandeep Dahiya.
Respondent
Lordship.
number 2.
Aditya
Learned
Agarwal,
counsel
Lordship.
for the respondent number 2.
Aditya
Since
Agarwal.
the matter is being hotly contested, let this matter be listed for hearing after 2 weeks without requiring a notice to the respondents, as the respondents are duly represented by respective counsel. List after 2 weeks for
My
hearing.
humble request.
Lordship,
My lords,
updated
just one
for-
request.
want
My
to
lords,
say-
one request.
Lordship, actually,
My lords, may kindly put
after
up a
lodging
my
the
lords,
FIR.
Mr. Counsel, please 1 minute. My lords, just one request. My lords, may kindly put up a next date to it, as my lords,
Yes,
without any date, it becomes difficult.
I request both of you to physically present and argue the matter. It's this part of the area is very difficult to have a proper grasp of your argument over the BC.
My lords,
We cannot reject your prayer to appear through the BC, as you know. But then, unless if there's a proper communication between the court and the councils, it's very difficult to, decide a matter.
Yes, Lordship.
So I request,
Lords-
after 2 weeks or 3 weeks, or 4 weeks, we'll fix the,
Lords-
we'll fix the
Okay.
date and you join us physically so that properly it could be heard and decided. All
My
right.
lords, fix up a date, my lords. And my lords, just one more information I'd like to provide. My lords may direct that we can appear via was listed for final disposal of the case.
Yes,
But
I
my
said I'm
option-
listed for hearing. I said.
Lordship, I want to
Well,
mention.
You come
Knowing
to you agree with the date on which it should be fixed.
Yes, my lords.
Yes,
Just
Lordship.
When?
Just a short date, my lords, I'm fine.
When?
My lords will put up
I
next week.
request you, I suggest you to appear physically so that it can be
Okay.
heard and
Okay,
decided.
My lords, I am sure so. Even I appeared physically once as per my lords.
When do we want?
My lords, may put up
You agree with the date? When it should be listed?
13 or 14th December, Lordship. 14th December.
Saturday, Lordship.
13/12/2023.
Okay, Lordship.
Hmm.
Lordship, my humble request is IO has freeze my account, Lordship, my business account. Kindly till then
It's
defreeze my
okay.
account.
We'll hear you, sir. If possible, this same thing will have a problem on that day. So better come present physically and argue the matter. All right.
Lordship, I am actually from Delhi and
I know.
petitioner
That's
is-
why I'm asking.
Yes,
That's why I'm
Lordship.
requesting to join us physically so that it can be properly heard and determined. All right.
Right.
Lordship, this updated case there is till 31st October, then updated case.
You ask.
Oblige,
Do I
Lordship.
record it? Not necessary.
No, Lordship, not.
You bring it. You ask for that and bring it. This speaks on 13.
Lordship.
Yes.
Apply.
Lordship, is a
What
negative.
is this affidavit in opposition? In appeal? Why affidavit in opposition? What is to be done? Why is listed for today? Orders today?
It is for service of.
So you are appearing
Yes.
for all the, how many, one respondent?
I'm for appellant.
Appellant,
Yes,
so how many respondent?
There is five respondents.
You are appearing for all.
No, I'm appearing for respondent 1 and 2.
Another respondent already the notices served, but
All.
only number respondent number 4. The notice is not service not completed.
Office note doesn't show anything, where it is. Received notice duly received. The same place.
Office note, Your Honor, Your Lordship, 24/10/24.
They received the respondent and attend place to it. Third, Mr.
Yes,
Your name, please.
yeah, SP Phukan,
Ah,
Your Lordship.
Learned Counsel for the appellant. Mr.
Tita Tak. For respondent 1 and 2.
Learned Counsel appears for respondent 1 and 2. Mr. Office note indicates that notice has been served to the respondent number 5. Then remaining is 3 and 4.
There is only 4.
Whatever 3.
24/10 in the office note, the reflector 3 is in served. 4 is not served as he is not present in a.
So how is what should be done? You find out and who is 4?
4's driver is not.
You find out what is to be done. Whatever they are saying, but okay, respondent number 3 also.
Your Honor, basically.
They served notice duly signed by respondent in the same place with the court. Okay. Okay, just then you just said so and so after this, Mr. So and so appears for respondent 20. Office note then indicates that respondent number the service in service services are complete in respect to respondent 3 and 5. For respondent number 4, no, for respondent number 4, it is seen that unserved notice has been returned back as the respondent number 4 has left Bombila. The appellant to take steps. Take appropriate steps. Whatever
Honor,
you have to do, you do it. At least after
Basically,
4
they are the performer respondent.
4 weeks.
I am the affected person. I am the appellant, the acclaimant 1 and 2.
Since he made a party, let him try what is to be done. Okay.
Obliged.
Obliged.
Non-appeals service ever service report list after 4 weeks.
May Your Lordship.
Yes.
Your Lordship, this is also joint petition, Your Lordship, for questioning of an FIR.
What is been listed?
Yes, Your Lordship.
Heard Mr. So-and-so learned counsel for the petition. And also MS El Hagel and additional. Why this has been listed today? For order.
So LCR, the scan copy of the entire record was called for loss.
Okay. Scan copy of the trial court record is received. List for admission after 3 weeks. 3 weeks.
Just after 2 weeks.
2 weeks.
And Your Lordship, there's an interim.
Interim order person.
Well, this case, of course, there would be a paucity of time today, but kindly fix it in the admission column for the final disposal on 10.
Heard Mr. Titi Tara, learned counsel for the petitioner. Petitioners.
Petitioner. Single. There are 2, my lord.
And Mr. Opada, my lord. Special PP. Special PP for SIC. Vigilance.
Your Lordship,
And-
I'm for respondent number 4.
T Gini. Additional PP.
Yes.
Additional PP.
This is-
for respondent number 4.
This is very interesting case, my lord. Without prosecution.
How it is
sanction-
interesting?
Without prosecution sanction, trial has come.
Are you seriously pursuing?
Yes, ma'am. Yes, ma'am.
It's a criminal petition.
Yes,
If it is interesting,
just in nutshell, just,
why brought before the court?
because,
Make it more interesting also before.
no, trial, that is something, where there is abuse of law.
On the,
Tenth.
joint prayer of learned council, as agreed to by the learned council for the parties, let
Correct.
this matter be listed
On 10 December for
on
disposal.
10, 12, 2020.
Much obliged.
10 December is a special, auspicious day for you.
No, because my brother will come back on 9th
Okay,
from Pasighar.
okay.
9 is the Monday, so I want it on Tuesday.
Well, that Saturday and Sunday hangover, that is peace.
Yes. No steps. Why you
Step
are-
has taken, Lordship,
When?
on next date only, through registry,
It's-
High Court registry.
Steps for service of notice not yet taken upon respondent by the learned council. So this office note is wrong. When did you take this step?
Then only, on next day only, we,
Show us. This is the order. Heard Mr. So-and-so, learned council. NMS. Allah Galan Listen. Office note dated 28/11/2024 reflects that no steps has been taken by learned for notice upon for service of notice upon respondent number 2. Respondent number 2. Is there interim order?
yes,
We're vacating it.
Lordship, it may be continued. Meanwhile, we'll take fresh steps.
So why are you lying or office is lying?
I'm not lying because,
So office is lying.
no, I don't know.
We'll call it, we'll find out who is lying.
Yes, that we have served the
Or
copy to
who is
registry.
in charge of this? Huh? Who makes the note? Office dealing, call them.
Lordship, may please allow to take a fresh step.
So now you are lying. So we'll allow, but they will vacate this stay.
Lordship,
Anyway, don't do that again. All right.
yes, Lordship.
Learned council by the petitioner is granted further 3 days time to take steps, 4 days time to take steps for service of notice upon respondent. All right. Interim order to partial country.
Highly obliged. Yes, Lord.
Last warning.
Yes, Lordship.
Don't do that mistake. Because office, there may be a mistake, but office, you'll have to cooperate.
Yes, Lordship. I will note that. Thank you. Highly obliged.
Please start.
4 weeks. 4 weeks. After 4 weeks.
May I please, my lord?
Yes.
This IA applicant is for to complete as a petitioner number 42 in instant with petition, my lord, 628 of 24.
You are for? You are petitioner. You are petitioner. So you want to, who has to be impleted?
This applicant, my lord, this IA applicant.
Okay.
Applicant want to implement in the instant writ petition in 628 of 24 as a petitioner number 42, my lord,
42.
my lord.
Okay.
In a
Any objection?
Your Lordship.
You are also representing other petitioners.
yes, my lord.
Okay. heard MS
Open.
learned counsel for the applicant and also heard. No, I'm hearing for respondent number 3. Okay. Any objection? No. MS also heard MS P. Pango, learned counsel, learned state counsel for respondent number
5789, Your Lordship.
5789 and MS Mr. Opada for respondent. In that case, you just heard Opada for respondent number 3, learned counsel, and then you write. This application is filed for praying for implement of one series. Narging or Narging?
Narging Dugmik.
Narging Dugmik as petitioner number 42 in connected writ petition number 628 of 2023. Why he is to be implemented? Why he or she? Why he is to be implemented?
The same course of action. My lord.
Yes.
It's the same course of action that, my lord. Earlier, the government have. That is in affected, the same course of prayer.
Next para. MS so and so, the concept for the petition, the applicant submits that. The proposed petitioner is directly and substantially interested in the subject matter of the writ petition. Who is also having a common cause of action with the petitioners in the connected writ petition. Therefore, she submits that the present applicants may be allowed to be implemented as petitioner number 42 in the connected sense. The counsel for the respondents raises submits that they have no objection for implementing the applicant as spread by him. Next para. Considering the submissions of the learned counsel to the parties. And that the petitioner, the applicant appears to have a substantial interest in the subject matter pending, subject matter in the connected writ petition. I deem it appropriate to allow this application accordingly. The applicant, namely Sri Nargi Dugmik, be allowed to be implemented as petition number 42 in the connected writ petition number 628 of 2020. Application stands allowed to dispose of. In writ petition, in view of the order passed so and so, the petitioner learned counsel for the petitioners to file an amended post item and thereafter registry to do the needful. Then the list the matter after 2 weeks.
2 weeks.
I hear this one.
Item number 20.
We'll take up the further matter first.
In that case, my lord, this may be taken up some other day. Second appeal will take some time.
Okay.
After a week.
Okay. It will be better because.
Lordship, this is a very long pending matter.
It's
Because to be witnesses in the
Okay.
parties is very all.
a second appeal. Second appeal.
Yes, second appeal. That is why particular date. will be
You
fixed.
agree with that, we'll fix. When?
And, second week of December. Particular date. 12, 13, 14,
On the joint, heard Mr. Deepang, Land Council for the.
Monday on.
And Mr. T. Tapak, Land Council for the respondent.
Maybe
On the joint prayer of Land Council for the parties, let this matter be listed on, listed on
10 December.
10/12/2024.
Okay.
This also. T. Tapak.
Not ready. This matter may also be adjourned.
Is it?
Yeah.
Mr. T. Tapak, Land Council for the appellant submits that he is not ready with the brief, ready with the case for argument. Therefore, press for listing the matter after
2 weeks.
After 2 weeks. There's nothing to be, nothing to be heard further.
Yes, my lord.
Only you have to submit the written
Records, my lord.
records and the written.
Yes. My lord, this is the records of all the 4 bidders, my lord.
Okay.
The top one is the, my lord, petitioners, down below are the, my lord, they are the,
Respond,
they are the private respondents.
Private
my lord.
respondents.
Yes, sir. And, of course, my lord, in
Is there
this,
any, all the file notings are there?
file notes are not there, but how they have assessed, how they have given the mark, the
Yes.
tender committee.
Yes,
That
yes,
is there.
yes,
That is
yes.
very important,
Okay,
now. So I have marked it.
Okay.
Yes.
Lordship, in item number 22, I'm filing the written submission on behalf of AK Sahiwala.
22.
22, Your Lordship. And item number
Mark it,
23 and 24.
put it in the, I mean, respective,
Number 23, I think. It's different. That one is item number 20.
connected file you put it. Or 22 you have filed separately and item
Yes.
23.
22 is separate. Item number 23, 24, 25, it's
They are same.
together.
Same,
Then,
together.
Lordship.
Okay. We'll just give those name also. Art so and so, so and so. You just give the seat at the last order. Learn it in, this in item 22.
Item number
No,
23.
this will be listed same order, common order. Then you find out those senior counsel. S. Datta, assisted by so and so, then
Item 22, my lord.
Sahewala,
Yes, Sahiwala.
then Sahewala, assisted by so and so. And writ petition so and so. We find out, huh? J.N. Sahewala in writ petition 115.
22, my lord.
20.
Sahiwala in item number 22.
No, writ petition number 1115. 115 of 24. And this Mr. S. Datta in 93, 105 and 227.
Lordship.
Then also had Mr. Arachanabam Lanan, Additional Advocate General for the state. Non-appears for the respondents number, private respondents, huh? You just find out the number, their respondent numbers. Hearing concluded. Judgment reserved. Problem is I'm leaving tomorrow for Guwahati again.
Only I can ask my lord for early disposal because it's a tender matter.
We'll try.
My lord.
Deeply obliged.
Deeply obliged, sir.
My lord, one more thing, my lord. Your lordship may be looking for the original document. My lord, these are the e-tender, my lord. So all the documents you
download.
is downloaded one, my lord.
Digitize. Can we, sir, yes, call the another. Sir, sir, excuse me for some time, 5 minutes.
5 minutes, yes.
Or 10 minutes. Have your garam chai? Go and have a garam chai.
Both ways the law.
Well, resume at
12.
12. One hour would be enough.
हाँ, more than enough.
Approximately 30 to 40 minutes. That's it.
No, just to recap, the last time,
Where's my note?
yes,
Just wait, just wait.
one note was there. Note of the-
Yes. This is 183.
Yes,
183.
yes. Last time, my lord, we have handed over one note also.
Yes, yes.
I will also refer to that. But before that, my lord, I will just recap in a short way what was argued by me. So, my lord, we
Yes.
pointed out the difference between section 81 and 83. Qua section 86. If your lordship will recollect, 83, there are three things: 81, subsection 1, clause C, which talks about the verification part. The proviso speaks about that if there is an allegation of corrupt practice, an affidavit, Form 25.
Yeah.
And then all annexures of schedule attached to the election petition should be signed. These are the three things in 83. Now, 86, I have referred last time, not 86 does not refer to 83. It says the High Court shall dismiss a petition if it doesn't conform with 81, 82, and 117. The 83 nowhere mentioned.
Yes, yes.
81, my lord, again, my lord, 81 subsection clause subsection 3. It is in two parts. One is the copy has to be given, the number of respondents, same number of copy, and it should be signed as true copy. 83 subsection 3. One is the number of copies. There is only one respondent, so we have filed 2 copies, one for the court, one for the service. That is the requirement under 81 subsection 3. And the second part, I'll just read out, Miller.
Yes, you have filed the copy of the chapter 8A.
Yes.
Along with the
Yes, we have filed that.
requisite copy.
Then
you proceed there.
So I have shown that checklist also and the file notings also. Now, my lord, coming back to the list of dates which I have last time submitted, your lordship has that? Yes, my lord. So what I have mentioned, my lord, what happened on 16th of July 2024. So, my lord, that time, 16th of July is the date of filing. So on that day, my lord, the petitioner went to the office of the assistant registrar, and before the assistant registrar, who is also the oath commissioner, as well as the stamp reporter. So in front of him, both the petitions were filed, it was signed, it was notarized also, oath commissioner notarized it, and both the copies were filed along with all required stamp and envelope. Everything was filed on 2 copies, totally completely signed and completely notarized also, as per the requirement of 81 as well as 83. Complete satisfaction of 81 and 83. This can be verified, my lord. From I have called for the records, my lord, that has come, because the copy which was sent to the respondent by registered court once the notice was issued.
Yes.
On 31st of August. 31st of July, notice was issued by this honorable court. On 2nd of August, I have shown the file noting. A copy was sent to the respondent through a registered post. That copy, my lord, that copy could not be served for some reason because it went through the post. It could not be served. It came back. Now that copy is there, my lord. If your lordship just compare with this copy and that copy, it will show it is all pages signed. I will request, my lord, if your lordship may take up that there is a small envelope. This copy I have requested. They have brought it here. Along with the file, they must have kept it. It's covered in a envelope. The big one, I guess. This is the spare copy, the second copy. So this was sent by the registry on 2nd of August, as per the file noting. So this copy and the main copy is identical. It is notarized before the oath commissioner same day. These two copies were where the petitioner went, signed, notary took place, and one copy, both the copies were filed. When notice was issued on 31st of July, then one copy was sent by registered post, which has come back. This came back on 31st of August. Before that, on 22nd of August, because service was not complete, matter was listed, we requested for a dasti. So dasti was directed by your lordship, but this service was not suspended. This was continuing because that has not come back that time yet. Lordship has said 15 days, another time for service on this. Alternatively, in addition, dasti service. That was issued to us on 30th of August, that as per the list of date. So on that day, we received that copy, dasti copy, only the dasti notice. Since we don't have any other copy, because we cannot create a second copy of this, because this was on 16th of July, this was already notarized. When we received the dasti notice on 30 August, we could not have created the same notary because it would be backdating that. So whatever copy we had, we annexed with the dasti notice and served that. That is on 1st of September, serial number 8. And in between serial number 7, after the dasti notice was issued to me, this copy came back to the registry on 31st of August. So for me, there was no occasion to serve him this copy. And
so what is the procedure?
Well, the procedure is that I filed 2 copies.
I mean, procedure and the requirements.
Yes, yes, Milord. The procedure, Milord, the procedure is that I filed as 2 copies because there is one respondent, one for the court, one for them, along with the envelope and the stamp, requisite stamp. Now, once notice is issued, the registry will speed post send it directly. That is the procedure, Milord. It will be sent there, and once they receive it, they will come and appear before us. So they came and appeared on 11th of September. That is serial number 9. And they did not say they did not receive any copy or nothing. The 11th of September, they came and they sought time. And on 24th of September, they filed these applications. Now, what happened between 11th of September and 24th September is clear from their application. In para 2, they say they have inspected the file. They have inspected the file. And para 5 also, they repeat that they have inspected the file. And in the WS, in para 4 also, they say they have obtained the certified copy. And based on the certified copy, they have filed their WS. That is para 4 of their WS. So they come before this court on 11th of September 2024, did not ask for any copy. They inspect the file, get a certified copy, and on the basis of the certified copy, they file their WS.
Obviously, why they should ask for a certified copy?
Yes,
they will go by whatever they have.
Absolutely. So once they
that is one of the ground.
Yes.
So where the election petition can be dismissed.
Absolutely. Absolutely.
Why they should come and ask you that you give the proper copy so that I should not file an application or dismiss of the petition, which is not for non-filing of requisite copies.
I am grateful.
Obviously, they cannot.
I'm grateful, Milord, because the point that was argued by my learned senior colleague is that a copy should have been supplied before the argument. Milord, that part is taken care once they themselves apply and get a copy, because ultimate goal is whether there has been prejudice in their defense. If they themselves admitting, no, before filing, I have obtained a copy, and on the basis of this copy, I have filed my WS. So the matter ends there. So there is no prejudice.
It's
But-
okay, you may be
huh.
correct, but the whatever had happened, but then you cannot expect them to come and ask you before filing this IA.
Yes.
Then you give the proper documents.
No, they could have
Once
asked,
you give the proper
no,
documents.
not me, my lord, they could have asked the
Right.
court. They could ask the, when they appeared on 11th of September, they appeared before your lordship, they could have asked, "Ki, give me a copy." And in
Anyway.
fact, my learned friend has submitted last time, your lordship will recall that they went to the registry refused to give him a copy of this copy. So that was a submission which was made by the other side, my lord. So what we are saying, my lord, ki once they appeared, they could have asked for it because the copy has come back to the registry. They could have requested this court or the registry for giving him a copy. In any event, my lord, they have obtained a certified copy, and on the basis of that certified copy, they filed a reply. So ultimately, the objective, I will show from the judgments also, that what is the objective of 81? 81 is, you know, that they should not be prejudiced in their defense. That is the ultimate goal. The true copy, which has been defined in section 81, subsection 3, what is the meaning of that, my lord? I will straight away come to that, my lord. What is the meaning of true copy? Yes. One more thing, my lord. In their pleadings also, they are not saying in the IA 711, they are not saying because of any vital defect in the copy, they are not able to defend themselves. There is no such pleadings in their application also. They are only in form, not in substance. They are disputing that this is not exactly the same copy in form, but in contents, it is the same. They are not even saying that because this paragraph has changed, this word has changed. They are not. That's no such allegation. They are only on the form of it. That affidavit is not signed, notary is not there. That is not there in their dasti, not in these two copies, because 81 is specific to these two copies. These two copies is identical. These two copies are identical. Now, my lord, what is the meaning of true copy? That your lordship will see. May I just hand over this? This is a list of judgments which we will rely. Sir, ye copy.
Yes.
Yes, my lord. Now, the first judgment, my lord, is, you know, there are, I have just culled out, my lord, from 1964 till date, what is the law? This is the comprehensive note on that, on all the judgments. Now, there are 3 constitution bench judgment out of this 12 and multiple 3-judge bench judgment, my lord. Now, first 2 are the judgment, my lord, by constitution bench, 5 judges. First is, I will refer to the first one, which is Murarka Radhesham. It is 1964, 3 SCR 573. This is exactly, my lord.
Yes.
What is the meaning of true copy, which is mentioned in subsection 3 of section 81? What is the meaning of that? So this has been dealt by Supreme Court a long time back, my lord. Now, your lordship may straight away come to para number 8, my lord.
Yes, sir.
I will first take your lordship to para number 11 at page 9. Cross check मेरा PDF page है ना, आप उस physical में देख लेना. Just above para 12. Para 12 is there, my lord. Just above that, I will read around 10th line from the top. I'm reading from having regard to the provisions. Lordship has that, having regard to provisions of part 6, Roman 6 of the Act.
Yes.
Around 10, 12 lines
Yes.
from the bottom. So before that, they discuss all English law and all. So finally, they come to this conclusion, the meaning of true copy. Having regard to the provisions of part 6 of the Act, we are of the view that the word copy does not mean an absolutely exact copy. It means a copy so true that nobody can by any possibility misunderstand it. The test whether the copy is a true one is whether any variation from the original is calculated to mislead the ordinary person. Applying that test, we have come to the conclusion that the defects complained of with regard to election petition so-and-so were not such as to mislead the appellant. So, my lord, the true copy in 64 Supreme Court say true copy is not the absolutely exact copy. It means a copy so true that nobody can by any possibility misunderstand it. So it is the substance. It is not the form. So if there is a change in the pleadings, the paragraphs are missing, paragraph have been replaced. You know, their names have been changed. Specific pleadings changed. Then it is of substance, not of form. So this has been interpreted by Supreme Court in 64. What is the meaning of true copy in section 81C? So none of such allegation is there in section order 11, order 7 rule 11 application.
Yes.
There is defects, whatever defects they point out is technical nature. So this is the definition of true copy. This has been followed from 64 till date. This is the law, Miller. This has been followed throughout. So test is there any variation from the originals calculated to mislead an ordinary person? So there should be an intention to mislead. Now, my lord, the next para, this same judgment also deals with, my lord, the defect in verification. So that your lordship will find at page number, para number 7. I'm sorry, para number 8. That is at page 7.
Yes.
So I am reading just above para 9. I'm just reading the relevant portion, my lord, because just above para 9, I'm reading 5 lines. It seems clear to us that reading the relevant section of part 6 of the Act, it is impossible to accept the contention that such a defect in verification, which is to be made in the manner laid down in the Code of Civil Procedure 1908 for the verification of pleadings as required by clause C of subsection 1 of section 83 is fatal to the maintainability of the petition. So there also similar point was raised, my lord, that verification is defective. Court held in 64 Constitution bench saying that these are not vital and it cannot, maintainability cannot be questioned on this ground.
Yes.
So verification, my lord, in any case is covered by 83 that I have pointed out. 83 verification is covered, 86 doesn't mention 83. Now, my lord, this judgment also covers another point which is very important, that treasury receipt. That your lordship will find at page 11, para 14. It starts at page 10, para 14. I am referring to page 11. So this is another ground they have raised, that 117. In the copy which they have received, there was no entry of treasury receipt. But in the original too, it is there. I'm only taking care of their copy which they have received. Now here, my lord, and this judgment, my lord, the defects which I am pointing out, the verification treasury receipt was there in the main petition. Even after that, court said these are not valid. Now, treasury receipt, page 11, I am reading just below this para 4, Vakalatnama duly stamped, just below that, the quoted part, italics, just below that. In the copy served on the appellant, the original treasury receipt of rupees 2,000 deposited by way of security was not reproduced. So there was one more defect of certified copy. We may just skip the next line. The line after that, as to the security deposit, it was mentioned in the body of the petition that such a deposit has been made. In our body of the petition, it is also there. Now, again, that certified copy difference is coming, that we can skip next line. It is obvious to us that a copy of the Vakalatnama was not required. This also we can skip the last line, my lord. Now, these are the 3 defects they have pointed out. Last line, my lord, we have already explained that what it meant is by word copy in subsection 3 of section 81. And we are of the view that defects pointed out on behalf of the appellant are not of such a character as to invalidate the copy which was served on the appellant in the present case. So, my lord, verification, verification and treasury receipt, both are taken care. And the definition of true copy. What is the meaning of definition of true copy? That has been taken care. Now, my lord, this judgment is a 5-judge, same year, my lord. There's another 5 judgment, the next one. The next one, my lord, is same year, 1964, S6 SCR 213.
Yes.
Sir. So, my lord, this judgment also, this constitution bench judgment also refers to the earlier constitution bench judgment, that which is at serial number 1. Now, here, my lord, they have also raised a point, my lord, that true copy was not mentioned in any of the pages where the petitioner has signed. My lord, a simple and plain reading of section 81, subsection 3 is very specific, my lord, that inscription of a true copy is not necessary if he signs, because it says he has to authenticate that petition. If he puts his signature, he is authenticated, my lord. But this is a direct judgment on that 5-judge constitution bench, para 6. Lordship has para 6, page number 3.
Yes.
So it says, my lord, the subject of controversy in this appeal lies in a very narrow compass. But before we deal with it, it will be convenient to specify the precise defect which the learned judges have held to be fatal to the maintainability of the election petition. As stated earlier, the election petition filed was accompanied by a number of copies required to accompany the petition under section 81(3), just like in our case. The election petition was typewritten and copies which accompanied the petition were carbon copies of the typescript. So there was no question of the copies being other than true copies. The copies bore 2 signatures in original of the election petition, authenticating both the contents of the petition as well as the verification thereof. The petitioner did not, however, insert the word true copy before or above his signature. The learned judge of the High Court considered that this rendered the petition one not in accordance with section 81(3) of the Act, and it is on this ground the election petition filed by the appellant has been dismissed. And it is the correctness of this decision that is canvassed in the appeal before us. Now, my lord, this is the contention. Now, para 20. The same thing has been alleged by them.
This
20. 20, huh? So it says, my lord, we are not impressed with this argument while we are conscious of the need for expeditious disposal of the election petitions and for the strict enforcement of provision designed to achieve this purpose. We cannot be oblivious to the circumstance that to read every requirement literally might equally defeat the purpose of which part 6 is intended. That is, the elections are conducted in accordance with the relevant statutory provisions framed to ensure purity and orderliness, and that the candidate who has not obtained a majority of valid votes or has obtained it in flagrant violation of the statutory provision is not held entitled to represent the constituency. The court has to deal with the similar question in the question of interpretation of words, which appeared mandatory in Kamraj Nadar versus Kunju Thevar. One of the points which arose for consideration was whether the requirement of section 117 of the Act, which then required the petitioner to enclose with the petition and government treasury receipt of 1,000 in favor of the treasury to the election commissioner, had been accompanied with by the election petitioner, and section 94 of the Act, which corresponded substantially to the present petition, section 90 subsection 3, required the election petitioner to dismiss the petition which did not comply with section 117. The petitioner in that case had made the deposit of the requisite amount in the institutions named in the section, but the deposit was made in favor of the election commissioner and not in favor of the secretary to the commission as required by statute. It was contended that the petition did not conform to the provisions of section 117 and had therefore to be dismissed by the tribunal. This court rejected this submission, and after adverting to the purpose of the provisions, held that this was fulfilled by the deposit made, and that though the requirement as to deposit was mandatory, the same was complied with by the deposit made. So, Milord, you have 2 things, Milord. Here, Milord, 117, they've deposited somewhere else, some other authority. So, court said that is also okay. Not the correct authority which is mentioned in the rules, some other authority, it is okay. Here we have deposited, the receipt is there, And as far as the earlier contention is concerned, my lord, that that true copy did not be mentioned. That final conclusion is page para 28, last page. Just above para 28. The last line, my lord. The decision of this court in Murarka case, that is the 5-judge bench I've just referred, is authority for the position that absence of a writing in the copy indicating signature in the original would not detract the copy from being a true copy. In the circumstances, we consider that there has been substantial compliance with the requirement of section 81(3) in the petition, which was filed by the appellant, and the learned judges were in error in directing the dismissal of the petition. So, my lord, this is where the substantial compliance qua section 81(3) comes in, my lord. So here also the court has said that true copy is not necessary. Even the signature everywhere is not necessary. It has to be seen substantial compliance. What is substantial compliance? That it is in substance, there is no difference. Difference in form, even for 81(3) is acceptable. So this too, Constitution Bench judgment, my lord, clears the field.
Yes.
So now, my lord, this two judgment and the law laid down by these two judgment, as far as 81 and 83 is concerned, has been followed throughout. There is certain variations which my learned friend has pointed out, my lord, in 1974 and 1995. Those two has been taken care. I will come to that, my lord, because my senior colleague has placed 7 judgments. Out of that, 4 has been directly overruled. The first 4 judgments directly overruled by Supreme Court. Now, entire case, the substance, the foundation of his case was based on those 4. I will show all, and the other 2, I am also relying on that. He is only relying on a point that copy has been supplied before argument. I am saying he has gone through the certified copy, he has obtained the certified copy. There is no need for that. And the last judgment, Joshi, 1991, that is also overruled by implication, Miller. So I'll come to that, Miller. Now, the third one, Miller. The third one in the series. Now, this judgment, it's a 2-judge bench judgment, now implements the Constitution Bench judgment. And these facts are even gross, Miller. These are like, in this case, my lord, only the affidavit was signed in the original copy. No other pages were signed. Still, court said it is fine. Now, para 6, my lord. I'm sorry, it is para number 6. Yes, I'm para 6. And these are judgments, my lord. These are judgment on the copy which was, or the original copy as well as the service copy.
Yes.
Now, para 6, my lord, it's very important, my lord. Now, this judgment refers to the earlier Constitution Bench judgment, both the judgments, and now para 6 on facts it held like this. Now, it is true that no signature, para number 6, my lord.
Yes, yes.
It is true that no signature was appended by the appellant on the copy of the election petition proper, and the signature was placed only at the foot of the copy of the affidavit. It is only at the affidavit. But that, in our opinion, was sufficient compliance with the requirement of the last part of subsection 3 of section 81. The copy of the affidavit was for reasons already discussed. Part of the copy of the election petition, and when the appellant put his signature at the foot of the copy of the affidavit, it was tantamount to appending signature on the copy of the election petition. The law does not require that the authenticating signature must be made by the petitioner at any particular place in the copy of the election petition. It may be at the top of the copy or in the middle or at the end. The place of the signature is immaterial as long as it appears that it is intended to authenticate the copy. When the original signature is made by the petitioner on the copy of the election petition, it can safely be presumed, as pointed out by this court in Chandra Subba Rao, that is the second judgment below, Constitution Bench, that the signature is made by the petitioner by way of authenticating the document to be true copy of the election petition. Now, here the appellant placed her signature in the original at the foot of the copy of the affidavit. And the copy of the affidavit was part of the composite document, namely copy of the election petition. And hence, the signature of the appellant must be regarded as having been appended on the copy of the election petition. So this is clear, my lord, one place in the main petition, in the affidavit. Court has interpreted section 81 saying that this is complete compliance. Because your lordship will see, my lord, 81 subsection 3 it also doesn't say that every page needs to be authenticated by signing. It says that the election petition, the copy of the election petition has to be authenticated by signing. It doesn't say every page has to be, not even the rules say that. Rule 8A of Guwahati High Court rule doesn't say that every page needs to be signed by the petitioner authenticating. It doesn't say that. It says that it has to be authenticated to be a true copy of the original. So now, Milord, I'm reading the last line of this para 6. The requirement of the last part of subsection 3 of section 81 was complied with by the appellant in as much as the copy of the election petition was authenticated to be a true copy by the appellant by placing her signature at the foot of the copy of the affidavit, which formed part of the copy of the election petition. The High Court was clearly in error in dismissing the election petition under subsection 1 of section 86. So, Milord, this 3 judgments, Milord, sums up everything. That defect in signing, defect in verification, defect in not putting a signature, authenticating true copy, these are not valid grounds or technical grounds on which an election petition can be dismissed. Because Subbarao, Milord, that section, that para says that what is the purpose? Purpose is 81, that a proper petition should be filed and he should get an opportunity to defend himself. So if he is getting an opportunity to defend himself only on technical grounds, it cannot be thrown out. Because after all, the allegation has to be gone into by the court. If there is serious allegation, which after all affects the election process, which is the sacrosanct, the entire purpose is to protect the process of election. If that is important, this technical defects cannot come in the way. So, Milord, Supreme Court has substantially diluted the entire 81 and 81, the provisions of 81. And it says it is to be in substance. What is the substance of the case? Allegations. If there is change in the paragraph, if there is change in the names. Now the 4th judgment, Milord, in this page, that judgment, Milord, will clear everything which incorporates vital defect. Here is a case, Milord, where they have rejected, they have dismissed the election petition. And here, why they have dismissed, I'll point out. Here it is a vital, they say it is a vital defect. So, even if there is substantial compliance, if there is a vital defense, if the form, if everything is correct, but you change the paragraph, you change names, you change the allegations, then, so now, Milord, para 9. Para 9 at page 4. This is again 3 judgment, 1984, to SCC.
Yes.
Milord, in the note, I have given other paras also just to have a complete idea about the facts, but I am just referring to the relevant paras. Lordship may note those paras, just mark those paras. Para 9, Milord. In the instant case, it is admitted case of the parties that the mistake in the copy supplied to the appellant related to corrupt practices indulged by him through various persons who have been named at page number 64 of the paperwork. In Murarka Radhesham, this is the first constitutional bench judgment. This court made the following observation. Having regard to the provisions of the act, we are of the view that a copy does not mean absolutely exact copy. This is the same repetition of the paragraph which I have shown. Now, para 10. In other words, this court merely meant to indicate that where the variation is so minimal and insignificant that it is incapable of misleading any person, as to the true purport of the allegation, it would be a substantial compliance of the provision of section 81(3) of the Act. The High Court has largely relied on the ratio of this particular case. Now, Milord, this para 10 is very important, Milord. If it is minimal and insignificant, it is incapable of misleading any person. Now, Milord, after this is the law, they have noticed the law. Now they come to the facts of this case. Now that is at just before that one para 15 also, Milord. They sum up the law also. Para 15, there are sub para 1 to 5, Milord. This is summing up the same thing again, what is held in the Constitution bench. I am not repeating this. Now, Milord, para number 17. Why they say it is vital defect? Now, in the view that we take, it is not necessary, para 17, not necessary for us to wade through a detailed discussion of the mistakes, because a few mistakes pointed out by the judge himself clearly revealed that they were of a very vital and material nature so as to mislead the returned candidate and prejudice him in his defense. Schedule 1 of the election petition contained a list of persons through whom the corrupt practices were alleged to have been committed. An analysis of these mistakes may be placed in 3 categories. Number 1, where there is a complete omission of the names which have been mentioned in the election petition but not in the copy supplied to the return candidate. So, my lord, there is complete omission. Names mentioned in the election petition, copy which was given to them, nothing, names have not been mentioned. Number 2, this is very important, my lord, to understand the vital defect. Number 2, giving absolutely wrong names which are bound to mislead the appellant in his defense, as the persons bearing the wrong names could not be traced out. Wrong names have been given. Totally. Number 3, some names given in the petition appears to be males, but in the copy given to appellant, they appear to be female. Now, para 18, my lord, they coming to the first category, the few examples will suffice to illustrate the point. So they're given details. These names have been omitted. Para 19, my lord. These names, spellings are different. Spellings are, so you cannot identify that person. Name of the person is different. Now, last, my lord, para 20. Para 20 is the final para, my lord. There are many mistakes in schedule, but we have selected only those which are vital and may seriously prejudice the defense of the appellant, because it will be very difficult for him to find out the names, namely in the copy supplied to him, who are said to have indulged in corrupt practices at instance. And finally, they accept the High Court judgment, my lord. They dismiss the election petition. So I'm just showing this, my lord, ki after the 3 judgments, 2 constitution bench and the 3rd judgment, my lord, this is the vital difference, my lord. Now, this is the law. If there is defect in substance, then only they can be dismissed under 711, not otherwise. And this law is continuing till date, my lord. I will show judgment of 2023 also, that these are the propositions of law is continuing till date. In between, 4 judgment came, my lord. In 75, 2 judgment came, and 95 and 97, 2 judgment came. Now, next page, my lord, serial number 5 of my this. So those 2 judgments has been dealt with by Supreme Court, and those have been overruled because they took a different view. Serial number 5 is Anil R. Deshmukh.
Yes.
So here, this was referred by my learned senior colleague also, my lord, saying that before the argument, they have given a copy, so defects are cured. So the argument is that we have not given a copy. But in this case, they have got certified copies. They have got certified copies, and they have drafted their WS based on the certified copies. And before argument, they have got it. So there is compliance of even that proposition also. Now, why I am showing this, my lord, on a slightly different proposition, my lord. Now, kindly have, because this judgment has shown that Dr. Shipra was doubted first time. Dr. Shipra, that judgment which has been, Dr. Shipra has been relied on by my learned friend, my lord. Dr. Shipra is SCC 1996 5 SCC 181. That has been doubted by this judgment, my lord. Para number 17, the last page, page 8. So Dr. Shipra.
Please, Paulos, this to be clear.
All right, because we noted down 7 judgments. So one of them figure. So, my lord, para 17, fellowship has that. Para 17 of R. Deshmukh. Last page.
Yes, we do.
It is to be noticed. So, gist of this I have given in my note, my lord. Fellowship may just compare with that. So, it is to be noticed that the reference is only with regard to the applicability of Dr. Shipra in cases like the one which arose before the said bench. In the light of the ruling of the Constitution bench referred to earlier, those are the 2 Constitution bench, my lord. In the light of the earlier, we have our own reservation on the correctness of the view expressed by Dr. Shipra case, but it is unnecessary in the present case to dwell on the same point. So I just wanted to show that they have been doubted. Shipra has been doubted, later on overruled also. That was also I point out, my lord. Now, lordship may come to the third constitution bench, serial number 6. This is the third one in the series. There are 3 constitution bench, my lord. Here also, my lord, page 24. Para 24, my lord, of this. Lordship may refer to my note. I have reproduced that paragraphs in bold.
Yes, yes.
So here also, my lord, para 24, page number 13. Reliance on the above observation in Dr. Shipra, divorced from the context in which that judgment has been rendered, is neither fair nor proper. So here also they have relied on it. 25. In our opinion, the principle indicated in Dr. Shipra case has to be considered as a confined to the facts and circumstances of that case is opined by the Ramasamy himself when this lordship observed para number so and so. The principle of substantial compliance cannot be accepted in the fact situation, in that case only, and cannot be considered to be of general application divorced from the fact given situation of a given case. Now, para 27 below. We therefore reject the argument learned counsel for the appellant regarding the applicability of the observations from Dr. Shipra case to the fact situation in the present case. So Constitution Bench also distinguishes Shipra and says in the fact situation of that case only that is applicable. Though it doesn't clearly overrule it, but later on it has been clearly overruled, the Dr.
Then you
Shipra.
come to that.
Yes, my lord. So here, my lord, I think I will just here, my lord, one para I would like to show, my lord, because here also seal and stamping was raised. Lordship may just note down that para. It is similar. True copy is again mentioned in para 35 and 36, my lord. What is the meaning of true copy and those things? And para 37 and para 39. So in para 37 and 39, my lord, finally, they say that stamp and seal of the notary is not relevant. This is the same principles, my lord. So I'm not reading out, my lord, because these are the identical, but this is the Constitution Bench judgment, a detailed judgment, my lord. One thing I want to point out in para number 39, my lord. Para number 39.
It's okay.
There was no pleadings by them also of being misled in their 711. Now, my lord, the next judgment, my lord, is serial number 7. This is the judgment, my lord, where the Dr. Shipra case has been directly overruled. Yes, my lord. Which is the para? Para 26, my lord. इसमें और एक judgment. Lordship has para 26 at page 17. Para 26 at page 17. What is judgment for PIS? So, my lord, Dr. Shipra came in 96, and then 97, another judgment case, which also my learned friend relied on, Harbachan Singh. So, Harbachan Singh is directly relied on Dr. Shipra. So, Dr. Shipra, these two is directly, so para 17, I'm just reading out. Page 17, para 26, my lord. The last, just above para 27.
Yes.
In Murarka Radhesham case, and T.M. Jacob case, these are the two Constitution Bench, have held such a defect to be curable and test of substantial compliance to be applicable. The very premise on which the decision in Dr. Shipra and Harbachan Singh Josh proceeded thus runs counter to the view taken by the Constitution Bench. In view of the Constitution Bench decision, Dr. Shipra case and Harbachan Singh case ceases to be a good law. So now, these two judgments have been relied on. These two has been specifically held, relying on Constitution Bench judgment, series of Constitution Bench judgment. These are not good law. So this is a direct overruling, my lord. And earlier also they have distinguished, my lord. So now these two judgments out of, I will show two more judgments, my lord, because this was the foundation of their case, my lord, when they argued. Lord, other relied paragraphs I have mentioned in my note, lordship.
Yes.
Now, my lord, I will straight away come to next judgment is, my lord. वो आ गया इसका copy? हाँ. This is 2003 1 SCC by 2 judge again. Earlier one was 3 judge. Yes, ma'am. So now, my lord, here. यहाँ पे कौन सा?
Yes.
Para 16, my lord, of this at page 12. From the various.
Mani Kumar Subba.
Yes.
Para
16, page number 12. I'll just read out now. From the various decision noted above, it is clearly emerges out that the correctness of the decision of Dr. Shipra case was doubted, and it has been held by the Constitution Bench in Jacob case that it was confined to the facts of that case. Therefore, it cannot be said that Dr. Shipra lays down any proposition of law of a binding nature. The two decisions of the Constitution Bench in Radhesham and Jacob hold the field, as well as decision in the case of T. Pungzathang, which I have shown in the previous judgment. The law as laid down in the above noted decisions would be the guiding precedents in deciding a question relating to a true copy of an affidavit. True copy of an affidavit. So, my lord, this is the law as it stands today, my lord.
Yes.
Any paragraph in this judgment?
It's okay.
Okay. Now, my lord. Ninth, my lord, we have only given last time. That is that judgment, which is Chandra Uttam Kumar, which was given to that draws a presumption in favor of the official work, my lord. That was the argument. But then we have shown from record also now that presumption is solid, consolidated, because the record shows, my lord, on that same day it was filed, it was not right.
Yes.
So there is no question of it leading any evidence against documentary, because oral evidence cannot be led against documentary evidence. Okay, But here, my lord, para 81 of this judgment, which I have already, lordship has that judgment, my lord, para 81. I will read from this, my lord. This lordship has the note. Para 81, if you see, Justice S.B. Sinha.
Yes.
On page 4.
R.P. Sharma. R.P. Sharma case.
No, my lord. This is page number, I'm talking about 10, serial number 10, my lord.
Okay, that you have shown here.
I'm sorry.
Chandrakant Uttam. It's okay.
9, my lord. Here, my lord.
What website do you have taken?
One just thing, because 81, para 81, from this, I'm just reading out. It is there. Which page? Para 4, it is written, page 4. It is written Justice S.B. Sinha. Just below that.
In the note. This is it. Yes.
So para 81, my lord. Because this para also seals the another two judgments, my lord, of 74 and 75 relied upon by my learned friend, my lord. 74 and 84. That is Satyanarayan versus Duja Ram and Rajendra Singh versus Usha Rani, which was relied. Very first two judgments, my lord. This has been directly overruled in para 81.
Yes.
So I'll just read out, my lord. It was held at para 81 that Rajendra Singh and Satyanarayan did not lay down the correct law. So it is specific, my lord, to that point, my lord.
Yes.
Yes. 81, na? Okay. So, my lord, now we are coming to, my lord, 2012, my lord. This is 2012 7 SCC. So here, my lord, I'm straight away referring to. We can read the note, my lord. In fact, that would be better. Paragraph number is mentioned. I'm referring to para number 16, the last two lines, my lord.
Yes.
It talks about general principle, it discuss 81, 83, all the same law. Para 16, it says the Supreme Court warned.
That are adopted by yes, that is around.
That is what is happening, my lord.
Yes, next.
Yes, my lord. Now, my lord, the last judgment, my lord. This is very recent, just to show, my lord, the same law has been followed. This is 2023 judgment. Justice Chandrachud and Narasimha.
Substantial compliance. Yes.
So here also, my lord, same proposition I have mentioned, my lord, the reference and the overruled judgment. This is the latest judgment on this, my lord. No, बता देते हैं.
So according to you, all the judgments relied on by the applicant they have been overruled.
4 of them directly overruled, my lord. I have shown those 2 judgments, my lord.
Yes.
One, 1991 Joshi, that is 1991 2 SCC 342. Joshi is, by implication, it is overruled because Constitution Bench judgment says there are 3 judge judgment. It is not referred anywhere. It has been ignored throughout. So though I could not find a specific judgment overruling this, but by law has been settled differently. So this has to be ignored. And the 2 judgments, my lord, 1999 2 SCC, that is Anil Deshmukh, which I have also relied, and 1999 4 SCC, that is the Constitution Bench Jacob judgment, my lord. That has been relied for the limited purpose that copies were served before the argument. Here I am saying, my lord, copies have been served because that is, in any case, they have obtained certified copies. This in fact helps the propositions of law laid down in those judgments, helps me only.
Yes.
Now, my lord, coming back to my original note, my lord, which I have given the list of dates and the 4 allegations which I have noted down separately, my lord. The other day I have given this. So I'll just, in view of this proposition of law and the judgments, my lord, I'll just one by one quickly, I will take your lordship to the allegations. So first allegation, set of allegation is the defective filing. The filing is defective. Number 1, they are saying stamp reporter compliance, though not argued, but I have filed the notification of the Guwahati High Court, my lord, where it says Assistant Registrar Judicial shall also act as a stamp reporter and commissioner of affidavit as and when required. This is the notification which is annexure A of my reply at page 31. So it is everywhere, even Assistant Registrar Judicial too, they all have the power. They act as a stamp reporter, and this was filed before the Assistant Registrar. So though not specifically argued, just want to clear this up. Now, number 2, serial number 2 of the defect, they say required number of copies not filed. So I have shown from the records, required number of copies were filed, along with all the requisites, envelope, everything. And it was sent to them also. The date of notary will authenticate that. 16th of July, both the copies were filed. Now, third is delay. That is not, again, covered by 2 because 16th of July, we have filed, the notary is there. It is clear. Now, the next page, second set of allegation is on the copy which has been served on them through Dasti. Now, my lord, Dasti, because this is here, my lord, Dasti copy was given because I have already explained this copy was already there in registered post. So we could not have got this. We could not have backdated the notary also. It is not possible. That will be forging and creating document. So whatever copy we had, we have given him. In substance, in form, it is identical. In substance, it is identical. They are not even alleging that it is different. In substance, they are identical. Now, my lord, if we see the first defect, true copy not mentioned. I have already mentioned the second judgment, my lord. True copy is not necessary. Constitution bench judgment, direct judgment on true copy. The second in my list of judgments. Now, number 2, endorsement by prescribed authority on Form 25. First Constitution Bench judgment. Third Constitution Bench judgment, Jacob case, Radesh, all on this form affidavit, no, not important. The third judgment in my list even says that 1 signature is enough in the main petition. They are only talking about the Dasti which I have given it, not about even the service copy which was filed. Now, unsigned annexures, in any case, my lord, unsigned annexures, if the affidavit is not necessary, annexures, it is directly covered under 83. 83 annexures, it cannot be dismissed. There's no defect because 83 is not covered by 86. And security deposit, my lord, it is there. Security deposit we have deposited. I have shown judgments where it says ki even if you deposit to some other authority, still it is okay.
Yes.
This security deposit, my lord, in my election petition, para number 13, we have given the details and the receipt is also enclosed at annexure 28 with verification. Para number 13 at page 59.
Election petition.
Annexure 28, yes.
Election petition.
Election petition, yes. Election.
Para 13, page.
Page number 59. Annexure 28. So this is also taken care, my lord. So, my lord, all the allegations, my lord, has been taken care of, my lord, because this is not a case, my lord, where, my lord, the entire small defects has to be looked into. Because that case, the fourth case, my lord, from the list is very clear what is the vital defect, my lord. The law has traveled a lot, my lord. And in between those 4 judgment key, which was a little bit different, so Supreme Court has taken care of those 4 judgment, but repeatedly distinguishing it and then not applying it, restricting its application to those cases only, and finally overruling it.
That's all.
That's all.
Sometime I can begin. So, to begin with,
Can we finish within 5 minutes?
I have to give it a time. I'll cover certain aspects.
After lunch.
After lunch. $19.99.
She is having the book.
Okay.
So. Para 21 is a distinguishing feature in Paulos.
Yes.
While referring to Anil Deshmukh and Dr. Chitra, Lordship says in para 21, reverting now to the facts of the present case, a perusal of the copy, they are talking about the copy, a perusal of the copy of the affidavit served on the appellant shows that the copy of the affidavit supplied to the appellant contained the endorsement that the affidavit had been duly affirmed, signed and verified by respondent 1 before a notary. Under the affirmation by the notary, the words, quote, SD notary were also written. What was, however, found missing in the copy of the affidavit was the name and address of the notary, as well as the stamp and seal of the notary before whom the affidavit had been so affirmed and who had attested the affidavit. Then comes the para 22, the defect, then with comparing it with the Anil Deshmukh case. The defect found in the present case is almost identical to the defect which had been found in the copy of the affidavit supplied to the first respondent in Anil R. Deshmukh case. The defect is materially different from the defect found in Dr. Chitra case. Where the true copy, so now they're talking about Chitra, where the true copy of the election petition furnished by the election petitioner to the successful candidate did not show that the affidavit filed in support of the allegation of corrupt practices had been duly sworn or affirmed and verified by the election petitioner before a notary whose attestation was also found missing. So practically, my lord, in these 2 paragraphs, Lordship summed up the entire thing. Now, my lord, here what do we find? The copy which was served on us, there are 4 pages that have been, I believe, signed, because my lord has seen the signature and we also have seen in the certified copy. So we would believe that would be his signature. It starts from para 83. At the bottom, Tadar Nanko, 84 Tadar Nanko, 85 Tadar Nanko, 86 Tadar Nanko, and 87 Tadar Nanko. If my lord comes to a conclusion
that these signatures in 4 pages would fulfill the requirement of paragraph 21 in the Pauno's case, well, then my lord, I have nothing more to submit. That is the only thing Lordship has to form an opinion. That is all, because there is nothing else in the entire bunch. Only this much in para 21 and 22 settle the whole case. Now, this is first part. Now, my lord, I'll come to, this is in respect of section 81 subsection 3. Now I come to section 81 subsection 1. Section 81 subsection 1 may not lays down the principle of 45 days limitation, within which election petition is to be filed. And it is not very clear that election petition, filing of election petition is not complete if the extra copies are not filed on the same day, along with the election petition for service. So the only issue is as to whether or not extra copies were filed. Now my learned friend has made a submission that on the basis of the records it is evident, according to my esteemed colleague, that copies indeed were filed. Now, my lord, I ask myself, is it really so? Are the records so clear? My lord, let me look into the records. What do we get on the name of the records? On the name of the record, my lord, what we get is the checklist. Lordship may kindly have a look at the checklist. I hope.
In election petition.
Yes, my lord, there is a checklist. Because this is the only record. Then I'll come to the office notes.
Yes.
Now, checklist, my lord, first serial 1.
Yes.
Not properly addressed to the court. Not is cut. So it is properly addressed to the court. I am reading it in a context because from the whole thing I will draw my conclusion. Not properly addressed to the court, there is a tick, not is cut. So I presume this is what is properly addressed to the court, the election petition. Number 2, the petition is not again deleted, typed legibly in double space on one side of page with margin and paragraph and pages, numbered and correctly noted in the index. Relevant words are cut, meaning thereby 1 and 2 positive. Then comes the 3. The contents of the petition and or accompanying documents is stroke are not clear, sharp and legible. My lord, there is no mark here. Was it not relevant, I ask myself? What do we make of this? Comes the 4. The true copy of the certified copy stroke original document required, as in it is not very relevant for this for our case, so I'll skip it. 5 is equally relevant. Address of petitioners, respondents are not set out properly. Representation of petitioner respondent, forget it. The learned advocate 6, the learned advocate has not put his full signature in the petition. Again, no marking. 8, the petition is barred by limitation and no application for condonation of delay is filed. We presume it is within limitation, so again not required, but then they are not indicating anything whatsoever. 9, affidavit not filed, notice cut, positive. 10, wakalatnama properly executed by the party and accepted by the advocate is not deleted, filed, positive. Likewise, 11, 12, 13 all clear. 14, the requisite court fee is paid, not cut. Likewise, 18, notice not served on the respondents. Now, my lord, notice not served on the respondent, correct mark is given because this is applicable. Obviously, we don't on the date of the filing, notice could not have been served, rightly so. Now, my lord, 19 is very relevant. 19, copies of petition insufficient. There is no marking here. My lord, in could have been cut. If I go by their logic, they could have cut in. Now, what do we make of this? Well, I ask myself, I am thoroughly confused. Now, my lord, comes the second argument. This is the record. So far as, my lord, the office notes are concerned, as per the office note, 1st of August, as directed by the Honorable Court, steps have been taken. It is like a writ petition procedure. By 1st of August, 45 days were over. How do we come to the conclusion that when the election petition was filed, 2 copies were there? How do we form such an opinion? On this, my lord, there are twofold arguments advanced by my esteemed colleague. The first argument is there is a presumption that if the High Court is an institution, if the High Court has done something, they have done in accordance with law, they have followed the procedure. There is a presumption for following the procedure. My lord, presumption is drawn when there is nothing to the contrary. But when the contrary indications are there on the paper, such a presumption cannot be drawn. That's one. The second argument is on whom the onus lies to demonstrate and prove and establish that the 2 copies were not given. Submission is that onus is upon the respondent. To this, my counter argument was, how do we prove the negative? The moment I show these materials, prima facie I show that there is nothing to establish that extra copies were served. The moment I establish that there is nothing to show that the extra copies were served on records, onus gets shifted on them. On this period, I am advancing my proposition. Proposition would be number 1, when it comes to proving the negative, there are pitfalls. And it is not for the respondent to establish the negative. And number 2 comes section 109 of the Evidence Act. Let us have a look at it. 109. No. There are 109 of the present Act, Old Act 106. Old Act 106, the new one 109.
New it.
Burden of proving fact, especially with the knowledge.
Yes, yes.
If it is universal, then page 50. Universal, lordship is also having universal.
Yes.
Burden of proving fact, especially with the knowledge. Now, my lord, this fact is in whose knowledge? Either to the knowledge of the election petitioner, conversely, may not their lawyers, those who did the filing. It is exclusively to their knowledge. Burden of proving fact, especially with the knowledge. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Now, my lord, examples are also given. A is charged with traveling on the railway without a ticket. The burden of proving that he had a ticket is on him. Apparently, my lord, the other person can't prove that he doesn't have a ticket. The moment he says, no, I have a ticket, show it. In Evidence Act also, my lord, other examples are given. There is a very interesting example of a doctor. There was an allegation that a particular doctor is doing a medical practice, but he doesn't have a license to do that. The argument was established that he doesn't have a license. He said, well, from his conduct it appears, the way he treats the patient, it appears he doesn't have a license, because no doctor having the requisite knowledge will behave in that fashion. Finally, the court ruled the controversy will be set at rest the moment license is produced. Onus is upon him to show. So we say, from the High Court, from the materials, it is not established that the extra copies were filed within the period of 45 days, along with the election petition. The onus is on them. They can very well establish, maybe due to their knowledge, maybe there are circumstances. So far as the respondent is concerned, respondent can only place the situation in the circumstances and whatever is available on the material to create a doubt. Now I come on proving the negative. What exactly is the law on the subject? On proving a negative. No, my lord, it is apparent. In addition, my lord, my further submission is, it is true, there is no report of the stamp reporter showing compliance of 81(1). It is very true. Had there been a report of the stamp reporter or report of the assistant registrar noting election petition received such and such with his endorsement, that along with the 2 copies, along with envelope and postage, it would have been over. No further requirement was necessary. There is no report, nothing whatsoever, nothing to indicate either this way or that way. And checklist shows something else. Because the moment you take something and you do not take the other things, a necessary inference, which is quite logical, can be drawn from the sequence. Not on proving the negative in the context of Negotiable Instruments Act. A very nice principles were explained. The 3 important principles. This one will find in Sarkar's Law of Evidence. Sarkar's Law of Evidence. I have the book, but then there are relevant pages from the Sarkar's Law of Evidence. I've taken the pages. I'll just show what the Sarkar thinks. Sarkar's Law of Evidence I'm placing in the context of 106. The old one, the new one is 109. Its application when it comes to election cases. Then I will come to the negative. The relevant paragraph below is paragraph, this is, I have marked it. Paragraphs are not numbered. Below my marked portion, Lordship may see, I will escape. I will not read further. It is clear below. It is applicable to election cases. I have marked that portion also. Now, it is on the other part. The judgment, I'll place it.
The entire exercise may not be necessary, my lord. If that envelope may be opened, then lordship may see on what date or notary has been, oath commissioner has signed it.
On that, I'll make my submission.
That envelope can be opened, it can be seen, my lord. If the date is 16th of July, it is clear. The owners, who has the owners, lordship may need not go into that, my lord. That envelope is there before the court, my lord. That will save time, that's what.
Oh, yes, that's correct. That's correct. That's correct. If that envelope shows that very particular date my learned friend is right, then this argument will not.
If the oath commissioner's endorsement is there on 16th of July.
Open it. On the other copy. So we have no access to that. My learned friend is right. Then this argument will not survive. See what is fair. Obviously. I have to. That's correct.
We expect.
Yes, because if he has done that, it will be there. We have no access to it. Then this point will go. Confidence of my esteemed colleague shows that it is there on that day. So otherwise, he would not have been so confident. So, I concede.
I will not be. Mine's case also. I just felt it.
If it is on 17th or thereafter, 45 days will be over. 45 days get expired on 45, on 17th. The date will be relevant.
The verification affidavit,
Yes, yes,
affidavit.
Yes.
Affidavit is page
16.
Not if it is a true copy, then the pagination has to be same. Page has to be 85,
No.
86, and 87.
You have a petition beforehand. The petition doesn't have that one. Your petition is before, additional pages.
No, I'm talking about the affidavit in the election petition.
What is the affidavit? It will be page 61.
It is 85, okay, 64. Acha, acha,
64.
64, 65, 66.
60 affidavit.
Start from
It has to be notarized, you know, the notaries,
63.
63, 64 is the two relevant, that is form, and then 65 also is the form 25.
the seal has to be there, otherwise date we can't. One may type it, 16 July and take out 10 copies, it will not help.
It's only the identified by Group Jyoti Kapil, Tadam Manku, date is 16 June,
Yes,
16 the July 2024,
yes.
but there's no notary, no seal, nothing.
On the left-hand side bottom, because
Doesn't have this page 63, start from page 63.
yes,
64
yes,
is first affidavit,
yes,
form 25 is 65. Right?
yes.
No nothing, no magistrate, nothing.
In the chamber. The question is.
It's only your, that is there,
Huh.
as usual, that format is the
Okay,
date
huh.
16 July. but
The petitioner
there's-
has, petitioner has signed, Mila?
There's a signature, but there's no seal and,
The question is not on which particular day they gave it. Before the,
This,
before the history.
This sign is not there, Mila?
which one?
This is page
Oath
number,
commissions.
oath commissioner, this
Page?
is page number 64.
No.
Not there.
Then what I.
Yes, then why not we can proceed. So then we know the date, what he's arguing is the date of
45 days.
placing that
Yes.
place on record.
So that was.
So he has signed, signature is there. So those 80.
No, signature is there,
There.
the identified by advocate also, but there's nothing, no seal signature,
So,
nothing.
so
No,
it is in compliance of
Of the
80.
not, neither or anybody else.
Correct.
Now we don't
It's
have
just,
some-
it consists of just signature of the petitioner and
Sufficient.
I would argue more, I'll argue.
there's nothing.
Because there is nothing to indicate that when the election petition was filed on 16th July, election petition is filed on 16th July, we understand. There is a oath, sign, seal, everything. 16th July is noted there. But along with the election petition, there were 2 copies on the same day. Is relevant to the case. There is nothing to indicate. Now when I come to the proving the negative.
You may see it also. You may see it also.
My lord, in fact, I would urge your lordship, at least this is the right case wherein lordship should make observations on the manner in which registry should perform
Yes.
when it comes to election cases. It is essential for assistant registrar who is acting as a stamp reporter to give his report. Whether election petition is filed along with the 2 copies,
If
whether
it's-
they are sealed, signed, everything. The checklist, they can't leave it blank without touching anything.
What have you seen?
Yes.
Because and marked it, 2 affidavit, while other one is form 25. The date is,
Page is signed. In my case, so there is nothing. Here also no date. Nothing is there. It is 24/9. We can. It doesn't have. So now what I come to proving the difficulty in proving the negative evidence. 1999, 3 SEC, page 35. Volume 3 SEC, page 30.
page 35.
Let me start from page 35. Not the relevant page, I'll be referring to 45 and 46.
Amin Chand, Yarelal.
Document straight away, turn to page 45. Page 45, I will start reading from Placitum G. Placitum G.
Yes.
Jones quoted in Patricia Satkaram evidence called addition, such and such. The second principle, which is relevant in the context, is the one stated in section 106 of the Evidence Act. That section states that when any fact is especially within the knowledge of any person, the burden of proving the fact is upon him. It is very generally stated that where the party who does not have the evidential burden, such as the plaintiff in this case, possess positive and complete knowledge concerning the existence of fact, which the party having the evidential burden, such as the defendant in this case, is called upon the negative or has peculiar knowledge or control of evidence as such matters. The burden rests on him to produce evidence. The negative averment being taken as true unless disproved by the party having such knowledge or control. The difficulty of proving a negative only relieves the party having the evidential burden from the necessity of creating a positive conviction entirely by his own evidence, so that when he produces such evidence as it is in his power to produce, its probative effect is enhanced by the silence of the opponent. So, prima facie I have to show only, then the onus will shift upon him. And before the Placitum G, Placitum E and F, the para just opposite to Placitum E and F at page 45 may also be seen. There is a quotation, from the Philosophy of Proof, second edition, page 153, in Cross on Evidence. Just opposite to Placitum E and F in page 45. Having referred to the method and manner in which the presumption under section 118 is to be rebutted, and as to how it thereafter disappears, we shall also make reference to 3 principles which are relevant in the context. The first one is connected with the practical difficulties that beset the defendant for proving a negative, namely that no other conceivable consideration exists. We had occasion to refer to this aspect earlier. Negative evidence is always in some sort circumstantial or indirect, and the difficulty of proving a negative lies in discovering a fact or series of facts inconsistent with the fact which we seek to disapprove. So finally, we know it is for them. Prima facie I can show. If they have not done it, they have not done it. I can't bring the evidence. So this is what it is. And lastly, number 1, on 45 days limitation period, as to whether or not 2 copies were there. That's number 1, that is 81.1. And then 81.1 is also connected with 81 subsection 3 part 1. It is the same thing. 81 subsection 1 supplements. It is supplementary and also complementary to section 81 subsection 3 part 1. It is supplementary and complementary. Because section 81 subsection 3 says, every petition shall be accompanied by as many copies thereof as there are respondents. And 81.1 says, within 45 days, along with the copies. number one, file it within 45 days from the date of election. And subsection 3, part 1 says, as many copies thereof as there are respondents. The two have to be read in conjunction. The second part of subsection 3 is, every such copy shall be attested by the petitioner under his own signature. So far as the second part is concerned, my lord, I have placed Paulos, para 21 and para 22. Both may be seen. If my lord thinks that that is good enough, then so be it. Now, my lord, I will come to few other aspects.
Yes.
Now, my lord, it has also been argued that so far as service copy is concerned, the argument is, on the direction of your lordship, by Dusty, in Dusty mode, copy was served. Since in Dusty mode, copy was served at a later date, it could not have been the exact replica of the copy filed earlier. This is the argument. You know, my simple submission is, there was no reason for them to have this very kind of a difficulty. The appropriate course of action for them ought to have been to get a certified copy and hand it over to us by Dusty mode. They could have done it. That would have been the exact replica. Instead of serving a certified copy to us by Dusty mode, they resorted to some other method. To their peril. It is not for them, it's not for me to advise them how to do it. That would have been the right course. They did not adopt the right course. Now comes the third part. Finally, well, how are you prejudiced? My submission is, my lord, I am prejudiced because when do I file? I appeared, my lord, before the Honorable Court on 11th September 2024. The first time I appeared with Wakalat Nama.
Yes.
I appeared on 11th September, the date on which the case matter came on board, after having received the service copy on 1st September to Dusty mode. They served a copy on me on 1st September. I get copy on 1st September. The matter was fixed on 11th September. I appear on 11th September, and naturally, there is a copy in my hand. I have to do all other exercises. It comes naturally to any counsel to say, well, we file WS, meaning thereby, merely by saying whether we file WS or we file some other thing. It is not for a lawyer to tell the Honorable Court, no, we will only file Order 711 application. We file something. Instead of WS, when we examined everything, because we have to go for a certified copy, we go to the registry. Registry will not show us registry will not give us the envelope. They will not open it. Only option was to apply for a certified copy. We applied for a certified copy, we examined everything, then only we filed Order 711 application. We could not have filed it. We wanted to know whether such defects are there even in the election petition. Had there been such defect in the election petition, my argument would have been entirely different. I would have said this petition, even the notice could not have been issued. Whatever, ultimately many things may happen. So I applied for a certified copy, and finally I filed WS written statement on 18th of October. Much later, because time is running by. 90 days requirement is maximum. Of course, of late bureau lordships have been rather liberal in construing the statute, but the maximum limit is 90 days. Time is running by. What do? Ultimately, what I did, namely, applying for a certified copy and examining it, and thereafter doing my exercise, I did their job. What they were supposed to do. Merely because I applied for a certified copy, I do not waive my right to argue that they failed to comply with the requirement of Section 81, subsection 1 and Section 81, subsection 3. These are mandatory requirements. The only dilution, my lord, in complying with the scheme of Section 81 is the Paulos judgment, which is the last Constitution bench judgment on the subject. And the core of the Paulos lies in para 21 and para 22. Lordship has seen both. That is the fact. So far as the other cases concerned, namely in para 22, Paulos referred to in para 22, Paulos referred to Anil Deshmukh. In Anil Deshmukh, the only saving feature was, even before the argument could be advanced, on Order 7 Rule 11 application, they served a good copy to the other side. That was a saving feature. But anyway, Paulos distinguished everything. Paulos said endorsement is there, other details are there, it's a good enough compliance. Why distinguishing Anil Deshmukh? What you will see more. I rest my case here and now. That is all.
My lord, as far as section, para 21 and 22 is concerned, and the affidavit is concerned, my lord, I have shown, my lord, the judgments as well as section 33. This is a defect under section 83, not 81. So therefore, 711 cannot be applied for this defect, and 21 and 22 of Paulo is
No,
not.
this not filing of requisite copy
Huh.
along with the main petition
Huh, my lord,
is not a defect under the
no, this is not a defect under 81.
81.
It is 83. This is a defect under 83 because the affidavit doesn't have an endorsement. That is 83, subsection 1C. That notary should be there. That is a defect. So 83, in any case, 711, it cannot be done.
No, problem is this was issued on 1st of August.
Huh.
You said you have filed this, the
Yes, that I will,
copies.
that date, date I will
Copies.
satisfy. That I will, what I'm saying, Lord, date, it's only question of when it was filed. That's the question because the date on
It
the
has
date.
to be accompanied with that.
So 45 days, 2 copies has to be there before the court.
Yeah.
That is the query raised.
Yeah.
Otherwise, this defect of notary is not.
See, this
Huh.
copies of petition insufficient.
Yes.
There's nothing, no cut or no.
Yes, but below, Lordship will see, just below that, there is one more endorsement, which I will just refer, that just below that, if Lordship see, case 21C, it is mentioned, and then just below that, right-hand side, the signature of the stamp reporter is mentioned, and the left-hand side, case ready / defective, it mentions case ready, the tick mark is there, my lord. So without the registry, when examines that, they have examined everything. We
And
have
then
also
this,
given.
this ink is also appears to be something different.
So
Guwahati High Court rules, chapter 8A.
correct. So this is what we have given to the registry at the
has
time
been
of
filed
filing.
along with the petition.
Yes. So this is we have given to the registry for at the time of filing so that they can cross check if these are the requirements and this is what we are filing. So it is for their benefit. We have given a copy of the order rule 8A. So this is mentioned on at the bottom.
It doesn't indicate that you have, we are not able to find out whether you have filed 2 copies on 16.
Yes, Milord. So why I'm saying, Milord, we have filed 2 copies. One is, Milord, that on the same day it was placed, that is my submission, Milord. Well, kindly have the rules also, Guwahati High Court rules. The Lordship may have that rules, rule 8A.
Just read it.
Yes. So rule 8A, it says, chapter 8A, rule. Yes, just after rule 1, there is a note which says any petition which is presented out of time or without any of the above mentioned requisites duly satisfied shall forthwith be returned by the stamp reporter for refiling. So, my lord, when we present this, if there was any defect, they should have returned it. They have not notified any defect.
No,
They have-
defect is not filing a second copy
Yes.
with the first copy.
Yes, that will
in
be
the
a defect.
election petition.
Because it will be a defect, my lord, if your lordship see rule 1, it says, rule 1 says each such petition shall be accompanied by as many copies thereof as there are respondents. So if I file a short copy, that will be a defect. Now, immediately after that, note 1 says, if any defect is there, the stamp reporter will immediately return to the
Since even in that sense, what your submission is, even if you have not filed a requisite copy,
right,
should have been
returned to me. That was not done. So therefore,
since it was not done,
yes.
So it is presumed that you have filed.
Exactly.
That how can we do that?
My lord,
you show us that you have filed it on the same day. 2 copies you have filed.
my lord, I can only
Then on that day, we know that there copy. This copy is there. This notice was issued. I mean, the state was on 1st of August.
Yes, yes.
We are not able to find out from the records whether 2 copies were filed on that day. 16.
Because the contemporaneous records, my lord, the checklist and the file notings, my lord, it shows, my lord, if your lordship go back to the checklist, my lord, it records that it does not mention anything, because if your lordship see the note also, the checklist also,
Yes.
kindly have the checklist, because everywhere where there is a deficiency or not, they are cutting that part. So even on the first page,
That's what I'm saying. That you come to serial number 9.
yes. So they are ticking that. So kindly have 18. Notice not served on the respondents.
It's okay. 19, come to 19.
19, yes. So copies of petition insufficient. If it was insufficient, but there should have some remark should have been there, Milord. That some remark that it is insufficient. So they have neither ticked, they have not ticked there. Wherever there is a tick, there is a problem or compliance, they have ticked it. They have left
Okay,
it.
according to 19 is copies of petition is not ticked. Therefore, it was, since you have filed 2 copies. so
Correct.
it
That's why they have not ticked it. And secondly, they should have returned it immediately if there is a defective short part. They have not returned it as per the rules, Milord. The presumption is in my totally in my favor, Milord. And even the document, Milord, if you see that, compare both the documents, Milord.
Suppose if it is, say, let us for a time being
Yes.
accept that you have filed 2 copies.
Yes.
If the other copy doesn't have that seal and signature
Yes.
and notarized, how do you accept it's an
Milord, that will come under 83. So for that, 711 petition cannot be dismissed at the threshold, because defect.
that is your submission.
Because 83, it is on affidavit, signatures not there. Those are the defects in 83. 83 is not covered under 86. So at the threshold, that cannot be dismissed. So defects may be there. When lordship opened it, that defect is there, but that defect is not for 86. It is only if we file less copies is filed, or in the original copy there are other defects, then that is there. There are 2 parts of 81. One is copies, short copies are given, and he has not put his signatures as to be authenticating it is to be true. He has put his signatures, and copies I'm from the checklist.
In fact, it appears to be they have done it as if it's a writ petition.
Yes, that is the problem. Because
let us admit that they have filed 2 copies. So they have followed the procedure in the writ petition, filing of the writ petition.
Registry was no.
Yes. It appears to be casually. It appears to have done it casually, very casually.
Difficulty for my learned friend.
Yes.
But Milord, my duty as a counsel is to highlight these very aspects. These are relevant aspects.
I'm told me not all other, there are 10 number of election petitions filed. This is the procedure has been followed.
If somebody, that's a procedure
It
has
should be correct. I agree with my learned senior colleague. It has to be corrected, because the procedure under the rules has to be followed strictly, because the stamp reporter has to prepare a report. But even if in this facts and case, Milord, I humbly submit, Milord, reading the checklist, Milord, the file notings, Milord, it is very clear in the rules, because if there is a defect, Milord, they ought to have been returned for refiling. But if it is not done, Milord, it cannot be on us, Milord, for dismissal, because these are all procedural aspects. The law we have stated very clearly, Milord, that what is the law, because substantial defect, Milord, even on this, Milord, the copies, there is no substantial defect. My learned for even after this, Milord, is not pointing out any defect which he is not able to defend because of.
I just forgot. I'll just raise 2005 also doesn't help them. In 2005, because that is the judgment they are latching on straight away. In 2005, succession to 2005, 2 SEC makes it very clear. In the case of Murarka Constitution Bench, each and every page was signed.
Here also, each and every page is signed.
Copy served. The copy served in Murarka, every copy was signed.
Here also the copy. Here also every copy, all the copies is signed. Petitioner has signed it.
That copy is not a copy served on us.
Therefore,
that copy would not act as a substitute of the copy given to us.
Therefore, my lord, again the rules, my lord. The rules, again the rules. It says, my lord, if the registered post goes and if it is not served, then order 5, rule 10 will follow. That is substituted service. Now, substituted service is publication. One of mode is publication. One is pasting, my lord. How can we paste 500 pages of election petition? Then he will come and say all pages are not there. It is only the notice goes, my lord. It is only the notice. It is only the notice goes. How can we publish 500 pages in a newspaper? So this alternative service has to be of the notice of the pendency of the matter, not the entire copy.
Not 2 things happen. First of all, my esteemed friend, Mr. Kapil, made a mistake by not giving a date. That is mistake number 1. Which Kapil did. And number two is the registry. Find it, you could have given your name. But it's there, sir.
It's okay. Good argument.
Service copy.
These are all procedural defects, my lord. It's all right, it's all right. Well, it is 16 days has been filed.
Relevant paragraph, 2005 to SEC, paragraph 24 and 25. Why the case cannot be like I forgot I told you about this. 2005 to SEC, paragraph 24 and 25. Distribution feature, very vital distinction. Here to note, 45 days argument was negated.
2005 to SCC.
Yes, para 24 and 25. The reasons recorded in para 24 and 25, the 45 days limitation period argument was negated by the Supreme Court. Registry very categorically said within 45 days it has been done. And copies are in order, the service copies. Murarka also, every page signed, they have spoken about it.
Murarka also, my lord, para 13, it records, we have already explained that what is meant by word copy, and we are of the view that the defects pointed out on the behalf of the appellant are not of such character, not as to invalidate copy of the service on the appellant in the present case. There also, my lord, the authorization was not there, the first defect. Verification and affidavit, there was defect.
Yes, yes.
Anyway,
so these are all defects under 83.
the paragraph numbers are, should I give it a slip?
You just give the, I think though I have recorded it, noted it down, but then can you give the list of books and paragraphs? Because here,
So I have given my paragraphs, my lord, along with that list.
Yes, yes. Just get the two list types and you combine it. Welcome.
नहीं the question is कि वो है in the service copy, my lord, our date is there, the notary date is not there. Not
No,
right.
that I'm saying.
Notary.
I want 83, huh? 20. Mr. PKT, what Learned Council. Learned Civil Council assisted by Mr. Learned Council for the applicant, respondent number 1. And also Mr. Rituraj Biswas, Learned Council for the opposite party, like election petition. The learned councils, the will say hearing concluded in this HHA and order reserved. I have to examine. Hearing concluded here, huh? In this order reserved. Should we fix the date for
Yes.
delivery of order?
Yes, that will be.
But it's very difficult.
That is subject to the workload of the document.
It's already overflowed.
So my lord, whether it's.
So that's why I'm also rushing back tomorrow. Like normally we go on Sunday. It will go to January. Because you have cited so many cases. Both side. November. December. We'll fix it on 23rd December for delivery. No, we'll just say order reserve list on 23rd. 23rd December. We'll see. Hmm. Which one?
Page one, just after the index, page one.
Yes, check. I'll just. Just after the index. And then the petition. Synopsis. List of dates. While by election petitioner, so any petitioner, nothing is there. Nothing is there. Just do a thing. You put this thing in the same envelope. Same envelope. You put the judgment separate and then a different.
Yeah, they told you about it, but we should hear it. It has been quite an exercise.